From item number 1 to 5. From item number 6 to 13. From item number 14 to 18.
Item number 21.
From item number 19 to 29.
21.
21.
20. May I please, your lordship? Item number 21, can you be pleased to adjourn for today?
The old matter.
PIL.
Old matter.
Yes, lordship. But my senior is busy with his wife's medical treatment.
You inform the other side.
Yes, lordship.
Adjourn. Yes,
May I please, your lordship? I would like to mention item number 29, your lordship.
29.
Yes, lordship.
Yeah.
But my senior is not well, your lordship.
Adjourn.
Obliging.
Item number 23, my lord, taken after vacation, my lord.
20.
23, my lord. I have taken consent.
Adjourn.
Lordship, with the consent of the respondents, I beg to mention item number 22, your lordship.
Yeah.
Can it kindly be taken up on any other day, my lord?
Again. Yeah.
My lord.
Adjourn.
May I please,
Madam.
lordship? Lordship, I beg to mention an repetition for listing, lordship. Is possible tomorrow, lordship. It was
What's
listed
the
on,
urgency tomorrow?
lordship, it was against the order of an interim order of an Kate order,
Appeal.
lordship.
It's appeal.
Repetition, lordship.
So what's the interim order? What's the urgency?
It is, lordship, the operation of the memorandum of search has been,
Memorandum of?
search has been state, lordship. Inquiry was initiated. It was state, lordship. Departmental inquiry was initiated against the respondent. And it was
Next week, madam.
obliged.
With his lordship. Your lordship, beg to mention item number 30. Here I'm mentioning on behalf of the state of Sikkim.
That it is connected with 39 or it's different?
30.
29. Okay, 30. Yeah.
Yes, your lordship. So I'm mentioning on behalf of the state of Sikkim, your lordship. I have taken the consent of senior counsel, Mr. K.N. Chaudhary, for the respondent, your lordship. Lordship, what has happened is the state council who is briefing senior counsel as Mr. S.S. Day. His mother is not well and in hospital.
This is the matter regarding sickness and non.
Yes,
Yes.
yes, lordship.
So we have informed that the consent. So we request for an adjournment.
Adjourn.
So lordship may please, if it is not inconvenient, in the month of May,
May, the first.
Second week. Second week of
Then
May.
you just ask the.
second week of May, any day, 10th.
Agreed
Of-
date.
date
please.
of life.
Obliged.
It may please your lord. My lords,
Mentioning order.
I beg to mention a fresh writ appeal for listing on Wednesday, my lord.
Why?
Newly filed. My lords, it relates to the Bihu festival, my lords, and therefore on Wednesday.
Festival.
Yes, my lords.
So, on Wednesday, why?
Buffalo fighting, my lord. My lords,
What relief you are claiming?
Lords, this is a writ appeal which is against a single judge's order which has allowed buffalo fights, my lords. And there's an
It is
SOP.
allowed?
Buffalo fights, my lords, more Jude during the Bihu festival. So,
Let it be open for one more year. Next time. After
lords,
being vacation.
lords, if, I mean, on Wednesday, my lords, no? That's on Wednesday.
After being vacation.
Very well, my lord.
Yes,
Daily list for orders item 1.
May I please? Last occasion, my friend sought time to bring inspection whether the respondent number 7 has been served or not through the Director of Secondary Education also. I see.
you are appealing for whom?
But we are appearing for the appellant,
No,
my friend.
Majumdar.
Madam, I am appealing for the education department, madam. We
Who
were
is the
required to,
respondent number 7?
but I had to serve it on the respondent number 7. Just been informed that it has returned back with the endorsement that address was insufficient. So now I have asked them to take the steps through the school where she was appointed. Try to trace her out. The address given in the petition and the writ appeal were insufficient.
He is in government service.
My lord,
Yes.
she was appointed.
How is, address is not known to the government?
My lord, the address given in the writ petition, they made a mistake. My lord, what they did was try to trace her out of the home. That is what I have been informed today. Lordship will give me a week or two. I'll have it served at the school where she's now serving.
Yeah, good.
We can trace her out of the school, my lord,
Okay.
that they overlooked.
Learned, Council Mr. Majumdar for Education Department seeks a week's time to get the notices of the respondent number 7 served upon her. Yes, Mr.
Obliged. 20. Obliged.
Item 2 and 3.
Hello, in this matter on the last occasion, your lordship was pleased to direct the government to take a call on inquiry
On the
committee.
inquiry report, yes, what step?
My lord, we are awaiting for the report, so my lord, assessment.
That report has already been, inquiry report as well taken by the state government. To apprise the court about the fate of the inquiry report as well as the measures taken by the state to the findings of the inquiry report.
My lord, that's true, my lord. I am, my lord, after that, my lord, process has been initiated for payment of compensation. But, Home Department returned to the, my lord, Revenue Department, Revenue and Disaster Management Department to sought for a assessment report, my lord, on the basis of which, my lord, compensation is required to be, my lord.
What is that? That inquiry has already concluded that this much of damage has been caused. That is there. Where is the question of
My
law
lord,
assessment?
This is assessment regarding individual, my lord, demolition of house, my lord. This is the inspection received from the Home Department, my lord. The process has already been initiated. My That is why, my lord, the Home Department brought for 3 weeks time, my lord, to complete the process. The second page, my lord, letter written from the Home Department to the, my lord, Revenue and Disaster Management Department.
Lord, here, if I may say, my lord, subject to, my lord, there were two issues, my lord. One is against the action against the erring officers. Second is the compensation. Because there was an affidavit file in the original PL before this honorable court wherein the government has stated on affidavit saying that no approval from any of the district administration was taken.
That was there.
So therefore, my lord, it is not only confined to compensation, my lord. And this committee has given report in the month of January this year. Till date, no decision. Incident happened in 22.
That's right, Mr. Das. But let the compensation be paid. We'll take care of that, whether action has been taken against the erring officers or not in there. first of all, your priority should be of paying compensation.
Yes,
the person-
the affected person is, yes, true, my lord, that's true.
Nikhil and counsel. Mr. D Nath. For state of Assam. Has submitted that pursuant to the report submitted by the one-man inquiry committee. The state government has taken up the matter and the government and the political department of the government of Assam has written a letter to the secretary to the government of Assam Revenue and Disaster Management Department to assess the loss on account of the demolition of houses of 6 persons. They submitted that as soon as the assessment report is submitted, the compensation will be paid to the affected persons. Mr. Das has placed on record the orders issued by the political department, government of Rajasthan dated 28th of March, government of Assam dated 28th of March 2024. The dated 5th of March 2024, 28th of March 2024, and 1st of April 2024. The same are taken on record. List after 3 weeks for further compliance. For submission of further compliance report.
My lord. Deeply obliged.
Item 4.
May I please, your lordship? My lord, in this case, on the last occasion, notice was issued and the office note shows that notice has been served.
Yes.
And my instruction is, my lord, we have prayed for interim order. So for consideration, my lord, the notice was issued. The writ petition has filed a contempt, but it's not appearing here.
As per the report of the Lozima Court, notice of the writ appeal has duly been served upon the respondent number 1. However, none has put in appearance on behalf of the respondent number 1. Stop. And the concept of the appellant has submitted that the respondent number 1 was working as a sector inspector trainee in the JDA. And later on, he participated in the recruitment process for the post of JN in the Department of Town and Country Planning of the state of Assam and selected. Full stop. It is submitted that the demand of the petitioner for pay protection, comma, which he was getting while working as section,
Inspector trainee,
while working as
sector inspector trainee.
section inspector trainee in JDA is unreasonable as his selection to the post of junior engineer in the Town and Country Planning Department is altogether a fresh appointment. Stop. Admit. Issue notice. Returnable 4 weeks. Register daily. In the meantime, effect and operation of the impugned order dated 14/9/2023 passed by the learned single judge shall remain stayed.
Deep.
Order to online registry jona bolaban urgent listing ase kali bhitor.
Item 528.
Item number three.
Item 5, my lord, we have
My lord, in item number 7, we have filed an application for modification of the interim order.
For modification of the
And
order,
here, my lord, service is complete in respect of all. This is a fishery matter, my lord, where the fisheries were settled in violation of the law. So therefore, the court interfered with the matter. And your lordship in the interim directed, my lord, the process of tender may continue, but don't take a final decision. So ultimately, they took, processed the tender and they took a final decision where, my lord, I was the beneficiary. Now, my lord, all the money has been deposited. Your lordship modifies the order, my lord. Or
my lord, today we have filed an objection, my lord. Let it come after the Bihu
objection
vacation.
regarding what?
As regards the stay vacation, my lord. We have served copy today, my lord. File one.
This in item number, this.
Here, 7, my
five.
lord, your lordship may detake it.
Item number 5, who is the respondent number 4?
Respondent number 4 is the. In item 7, my lord.
Item number 5.
5.
On item 5, my lord, we were directed to take steps, my lord. In item 5, we have taken steps, my lord.
Zahiruddin, who is the Zahiruddin?
He is the private respondent who was given the settlement, my lord, subsequently, my lord. So we have filed an impleachment petition.
Now,
in
they
item
say
5.
that the fishery is settled in his favor.
No, that is a separate matter. That is item number 7,
That is for a different fishery.
different fishery. This item
Then
5
why
is different
all
fishery.
these cases are taken together.
Because it's emanates from the same impugned order, my lord, impugned judgment.
I have a prayer, lordship. Regarding item number 7 and 8.
Now,
7 and 8.
Fishery is not in operation. Nobody is fishing. Nobody will enjoy Bihu, my lord.
so they enjoy Bihu.
Let the fishers enjoy the Bihu. We will not get fish in the market. My lord, let it, because my lord, what I pray, my lord, your lordship in the interim directed tender process may continue, but don't take a final decision. Wrongly, my lord, they have taken a final decision. I was the victim. My lord,
Them or beneficiary.
I was the beneficiary. Later on, I became victim because I didn't know about anything about pendency of the case. So ultimately, my lord, as per your lordship's order, they withdraw the order. Now a decision has to be taken whether a final decision can be taken by them.
So that contempt matter was there.
Contempt matter was there. Your lordship is correct, my lord.
Lordship has disposed it of. Lordship, item number 7 and 8.
Because my prayer is, my lord,
Prayer
till final hearing of the matter, my lord,
Seven
let
and
them
eight,
take a
lordship.
decision in the
Yep.
matter.
Readings are completed. In item number 7 and 8,
6 and 8.
steps are being completed. So that two matter maybe.
Is the order of settlement under challenge? No. Order of settlement is, but they have withdrawn it, my lord. Because of the contempt, my lord.
That they contempt matter.
We'll hear it on any date after Bihu vacation.
May I
My
tell
lord, can it be before Bihu, my lord? I just.
For Bihu, it's not possible. Well, only let the fisheries, fishes be enjoyed, Bihu. Let them enjoy Bihu.
The prices of the fish should be higher in the market.
Only on account of one fishery.
In that locality, I'll say, my lord. My lord, if it is possible, my lord, I pray it will.
Link it.
I have a prayer, Lordship.
Item number 5, IA number so and so.
Item number 7 and 8, Lordship. May
Just
Item 5, my lord, it is service is complete, my lord. In as regards item 5.
hold down. Hold. Common order we conduct 5, 6, 7, 8, whatever. In IA number 491/2023. Affidavit regarding the justice service upon the respondent number 1 has been filed. Stop. Taking into consideration the same, the notice of service of IA number 491/2023. On respondent number 4 be treated as complete. Full stop. Let these matters be listed on 23rd of April for admission.
As regard item 7, my lord,
All matters. Is the common order in all the matters.
only in 2 matters there is stay, Lordship.
5, 6, 7, 8, all matters.
Only in
is
2
the
matters
common
there
order.
is stay, Lordship.
Yeah,
Only in 2 matters there was stay, Lordship. That is
that is limited. Stay is limited or not?
not limited.
Then it's okay.
No, it stays
Obliged.
stays effective, Lordship. These 2 matters, in those 2 matters where stays there, Lordship. These, there 2 matter may be that Lordship.
We'll hear all these matters on the 23rd. For admission, we have kept it for admission.
Item 9.
Yes, last occasion we granted time.
Yes, Lord,
For,
a copy of the order it is,
Comply with the, for compliance.
Lordship,
No.
in fact, a copy of the order dated 2nd of this month, Lordship, has been placed before your
Copy
Lordship,
of the order.
passed by the learned Supreme Court, Lordship.
What is that?
The impugned order has been stayed by the, was
What is
preferred to be by the court.
Matter is regarding
Lordship.
This is,
the matter was.
This is regarding, the person who has been working in fixed pay since 2006, my lord, and there was a direction by this honorable court to encadre him, my lord. In the cadre of JAA, my lord.
So once the order is stayed, then this contempt petition, what we will,
Yes, ma'am.
will dispose it of, and granting you liberty. If occasion so arises after disposal of the appeal, you can file afresh.
My lordship.
Okay, learned concept, appealing for the respondent. I submitted that the impugned order passed by this court in writ appeal number 393/2022. Dated 28/4/2023 has already been stayed by the Honorable Supreme Court in a special leave petition, civil diary numbers 40056/2023 on 2/4/2024. Top. Para, in view of the fact that the impugned order passed by this court has already been stayed by the Honorable Supreme Court, we deem it appropriate to dispose of this contempt petition while granting liberty to the petitioner to approach this court again after disposal of the SLP by the Honorable Supreme Court if occasion so arises.
My lord.
Obliged, deeply.
Item 10.
Now, contractual employee, my lord, unmerited. Only, my lord, information was not given.
May
That's
please,
why.
Lordship, before the other side starts, Lordship, I have a small prayer. Lordship, if possible, can this matter be taken after some time? The council who is handling this matter, he's on legs, Lordship.
Counsel?
Who is handling this matter, Lordship, the council, he is on legs. In court number
It's,
26.
everybody is on logs, who is on my hands?
Lord- Lordship. If possible, can it be taken after some time? There's instructions regarding this case also.
Password for the time being.
Lordship. Much obliged, Lordship.
Item 11.
May I please, Lord. My lord, this rampant art cutting is still going on in the village area of this affected person, my lord. But the thing is that, my lord, one Assam Mala scheme was there, my lord.
Assam Mala.
Yes, my lord, road scheme, my lord. Under the scheme, my lord, your lordship will see page 57. The fund was directly released by the PWD department to the revenue secretary of NC Hills, my lord. And the revenue secretary was holding the fund, my lord. And subsequently, my lord, without following any due process of the Act 2013 Right to Fair Compensation Act, one after the other, my lord. This affected villagers, my lord, have been displaced, my lord. And this
Who is appearing for the respondent number 13?
13, my lord, the notice was served and
13, my lord, from our side, we have give them copy and an affidavit to that effect we have filed. It is
And
an affidavit as regards service of copy by the PWD department on the respondent number 13 has been
who is the
filed.
respondent number 13?
13 is the contractor, my lord,
Contractor.
private respondent.
now
So why are not dispersing the amount?
No, my lord, the PWD department, my instruction is that we have handed over the amount to the NC Hills, my lord. They are the NC Hills Authority, my lord,
North Kasar Hills, my lord.
not Kasar Hills, my lord.
Revenue secretary.
Not Kasar Hills Autonomous Council,
Who is appearing for that?
my lord. My
North
friend,
Kachar Hill Autonomous Council, you are appearing. Why are not dispersing the amount?
Lordship, as per my instructions which I have received, Lordship, we have received an amount of rupees 66,88,000,
66?
sorry, 66 for 88,72,943. That amount has already been disbursed. That amount has already been disbursed. Lordship, in that matter, Lordship, I would like to file a short affidavit.
Then what remains?
Lordship, amount
They
of
already dispersed.
My lord, for release of the amount, 2013 Act says, my lord, no process. They directly, my lord, from instruction I obtained, direct purchase method they are adopting. They go on the spot, select some of their selected villager. How much you want? Direct purchase, my lord. That is all with all
There
responsibility.
must be a determination that this.
Yes,
person
my
will
lord.
get So and so amount.
Right to fair compensation, my lord, totally not followed, my lord. And
No,
this
so
is
there is no determination that which
No.
person will get what
no
compensation.
determination, ma'am. That is my case, my lord. And
This is
Directly they, my lord, negotiate, my lord.
Don't you have the details that
Yes.
how you paid the money without even determining the compensation amount to the each person?
Lordship, direct purchase method is also there in the state of Assam.
Direct?
Purchase method of land by the department is also there, Lordship, which now the state government has adopted that method, Lordship. Without,
What do you mean by direct purchase? Which is the procedure of direct purchase?
Lordship, there is some procedure, Lordship, before.
It's altogether
Lordship.
alien to the Act of 2000.
Yes.
Lordship,
Contrary to that, my lord.
This is too much. It's like purchasing vegetables in the market.
No, yes,
with
no,
diya,
Lordship.
aloo kya diya hai. What is this?
Not like that,
How
Lordship.
you can,
Lordship, I am praying for some 2 weeks time to file our affidavit, Lordship, so that it may be clear.
But, my lord, what happened, my lord, with that gaining time, one after other affected person is removed, my lord. I have brought on eviction, some interim order, my lord.
Lordship, they
That
are
is
not-
my submission.
They are
direct
not
purchase, my
evicted,
lord.
Lordship. They are not being evicted, Lordship. As my learned friend has stated that they are
they
being,
are still in
Yes,
the
yes.
possession of the land, despite payment of compensation.
Lordship, some of them which have been got the compensation, they themselves have evicted themselves.
How can
They left the place, Lordship, of their own.
I have annexed, my lord, the photographs also.
Still learned concept of the petitioner has submitted that. So then a notice of respondent number 13 has already been served to PWD. However, none is appearing on behalf of the respondent number 30. Full stop. Para. Learned concept of the petitioner has submitted that the respondents state without paying any compensation to the affected persons are evicting them for the purpose of construction of road in question.
Assam, my lord.
Stop. Learned counsel appearing for the PWD has submitted that the compensation amount that has submitted that the state the PWD department has already deposited the compensation amount to be paid to the affected persons to the North Kachar Hills Autonomous Council. And it is the duty of the said council to disperse the same to the affected persons. Full stop. Learned council appearing for the North Kachar Hills Autonomous Council has submitted that the council was in receipt of an amount of around 66 crores to be dispersed to the affected persons. And the said amount has already been dispersed. It is submitted that the said amount is dispersed on the basis of direct purchase
Yes,
to the
Yes.
affected persons.
not to the affected, my lord, to some other person of their own choice.
What he is saying affected persons, it is his
His
submission
submission, I'm sorry.
to the affected persons. Learned counsel for the petitioner has vehemently opposed the said submission of the North Kachar, counsel for the North Kachar Hills Autonomous Council. Full stop. Taking into consideration the overall facts and circumstances of the case, we direct the counsel for the North Kachar Hills Autonomous Council to file a detailed affidavit mentioning the payment, mentioning the mode of payment to the affected persons.
Annexure 1, my lord.
The basis, the mode basis for payment of compensation to the affected persons. Positively by the next. And also furnish the list of beneficiaries. And also furnish the list of beneficiaries by positively by the next date of hearing. Put upon 22nd of April.
Yes.
Yes, Mr.
Lordship.
22nd of April.
Yes, my lord. Deeply opposed.
Item 12.
Mode and basis, mode and basis.
Wait, please, Lordship. Lordship, this IA is for continuation of delay of 33 days, Lordship.
You are appearing
I am appealing for state number sum 1, 2, and 5.
1, 2, and 5.
No,
What's the matter about?
Lordship, some fraudulent transactions had happened with the account of the private respondents, Lordship. The predecessor in interest of the private respondents, Lordship. And he lost an case with the CID. The CID have identified some IP addresses of the locations which were somewhere in Maharashtra. He also filed a complaint before the banking ombudsman. The banking ombudsman rejected his claim because there were so many evidences and documents to be taken care of, and as such, then he came before the learned single judge. Learned single judge held that although those transactions were fraudulent or not, but the bank has to pay the amount, Lordship.
Naturally, bank has to pay.
Lordship, but the CID had identified some people, Lordship.
No, you take action against them. But if the person is cheated of money from your bank account, you are responsible for that.
Lordship, but for carrying any transaction, Lordship, the PIN number and this card number is mandatory, Lordship. That has to be compromised. That's what we are saying, Lordship.
Not in every case. Not in every case. In fact, you have different type of rules. If a person files a complaint within 3 days, he'll get so much 100% amount. If after 7 days, he'll get 10,000, and after that, you'll not pay anything. This is absolutely bizarre.
There are many circumstances.
Notice of the application under section 5, the limitation act, but be prepared. MFSC, we are of the opinion that it's all high-handedness of the bank people and nothing else.
There is a judgment of this court also,
Yes,
single bench. Are
Yes,
you aware of it?
Yes, sir, Lordship.
Get that judgment.
Lordship.
These arguments have been rejected.
Issue notice of the IA number so and so. Mr. So and so put in appearance on behalf of the respondent number 1, 2, and 5. Let notices be issued to the other remaining respondents. Returnable 3 weeks. Registered 80.
Item 13.
May it please your lordship. This petition is filed for impleading the newly incumbent, that is Deputy Commissioner of Kamrup Metro Lordship, Sumit Satwan, as a respondent number 5 in place of 3.
You are appearing for whom?
Lordship, I am appealing for respondent number 3.
Was transferred.
3. Who is the respondent number 3?
The past DC which he has been transferred, yeah.
Now you are appearing for this present DC also.
We haven't got the copies, what implement.
What copies? He has been transferred
He has been transferred.
and the new DC has joined. You are for the government.
Yes, sir, for the DC.
DC, it means
You are
government.
appearing for respondent number 5 or not?
Respondent number
Newly incumbent.
We haven't got the copies.
Deputy Commissioner. Not the new.
As a private concept,
No, your
as a government concept.
No, as a private.
Right? How can there be government counsel in contempt matters?
that is happened in present. The earlier deputy commissioner.
Engagement is private.
If the matter comes upon for consideration of the IA number so and so with the prayer to substitute the respondent number 3 with the new incumbent. It is contended that the then Deputy Commissioner of Kamru has been transferred, and in place of her, him, a new incumbent has joined as Deputy Commissioner. Stop. Taking into consideration the contents, taking into consideration the above fact, we deem it appropriate to allow this IO and permit, allow this, IA, the respondent number 3, be then Deputy Commissioner Kamru is substituted.
As respondent number 5.
You have moved an application for substitution or
No, this one is only this one, Lordship, implement.
for substitution or addition?
Implement or
substitution?
Substitution in
Substitution.
place of respondent number 3.
Substituted in place of so and so, so and so. Let's stop it. Issue notice to the newly added to the substituted respondents returnable 3 weeks. Registered AD. He doesn't know what is the difference. Prayer is for implement.
Implement.
You filed for implement. Why are you saying substitution?
No, Lordship asked me for a substitution or addition, so I say that this is for implement.
Amended was stated already filed, we taken on record. You have already filed the amended was said.
No, Lordship.
Amended was will be filed within a period of 1 week. Issue notice of. Yes.
Obliged.
Item 14.
There is a delay of 4 days in preferring the customer.
All the appeals.
All the appeals.
Why?
4 days actually, there was some miscommunication with the calculation of dates, Lordship, in fact.
Notice of the application under section 5, the limitation act of the response. Returnable चारों में order करते हैं 15, 16, 17 and 18.
Up to item 18, Lordship.
Registered 18, returnable registered 18.
Much of it.
For admission, item 19.
Yes, Mr. Datta. Wait, Mr. S. Datta. Password for the timing.
Item 20.
May I please, Lordship? My lord, decision appeal required by the state, my lord. We agree for my lord imposition of cost of.
Why? For 10 years you
My
have
lord,
done nothing.
I am, my lord, not,
Ultimately, the cost is imposed on the deputy commissioner and not personally on.
no, my lord.
Then,
At that time, my lord, deputy commissioner was.
no, maybe the state has to pay the cost.
My lord, only thing, my lord, I am to my lord, this is a mercy appeal, my lord. If my lord,
No mercy with the government.
my lord, the factual aspect, my lord, regarding my lord, shifting of the office of the deputy
For
commissioner.
10 years, an application for compassionate appointment has not been decided. What remains then?
My lord, that has been considered, my lord. It is not that, my lord, it was
You have
not considered for 10
communicated it to
years.
That person.
My lord, lordship may kindly see the page 101, my lord. The affidavit in opposition. Page 101, affidavit file. Yes, my lord, Lordship may kindly appreciate my lord paragraph 4, my lord, of the order passed by the learned single judge, my lord. Wherein, my lord,
Review petition or in the main petition?
the main petition.
Main petition, yeah.
Page 98.
Fourth.
Page 90.
Yes.
The third petitioner has challenged the minutes of the DLC held on 4/6/2015 by filing this writ petition under Article 226 of the Constitution of India. In paragraph 4 of the affidavit in opposition filed by the Additional Deputy Commissioner on behalf of the referendum number 3, it was disclosed that the proposal of the petitioner was placed in the DLC meeting held in the year 2007. However, no documents had been annexed to the said affidavit in opposition. As per the order dated 21/2021 passed by that court, it appears that the minutes of the DLC held on 11/7/2007 was placed on record by the latest state council. My lord, on the basis of this, my lord, the cost has been imposed because my lord, record is not available. Lordship may kindly.
Record is not available now. You have dismissed his application in the 2007,
My lord,
then again dismissed the same in the year
2015.
2015. He moved an application for compassionate appointment in the year 2005.
Five.
As per your case, you have decided that application in 2007. Then why for the second time you have decided the same application and rejected the same in the year 2015?
My lord,
Why?
because of my lord, the pressure created by the other agencies of the.
What do you mean by pressure created by
My
other
lord,
agencies? He is
for consider,
poor fellow
for,
seeking
for
compassionate
considering,
appointment.
for consideration of his application once again, my lord. That
There is
that
no
is why, my
question of-
lord, it has been
You
placed
can
for
very
the
well,
second
you
time.
can very well dispose of the said application that his case was already dismissed.
My
in
lord,
the
that
year
is why, my lord,
2007
learned
itself.
single, that is why, my lord, learned single judge did not interfere in the, my lord, order of the DLC, my lord. What has happened, main, my lord, grounds on the basis of which, my lord, cost has been imposed. My lord, that is letter dated, my lord, 18/8/2007, by which, my lord, the deputy commissioner have communicated the decision of the DLC,
That is your case.
my lord. That your
Whereas the
lordship,
finance department
my lord.
has filed an affidavit,
There is
they
no
have not
record.
receipt of any such communication.
There is no record of such. My lord, if that is so, my lord, lordship may kindly see by that letter, my lord, not only the case of the writ petitioner was rejected. By that letter, my lord, DLC's decision for recommendation of two other candidates, my lord, that has been, my lord, recommended to the state level committee. My lord, that aspect of the matter did not.
Then what happened in those two cases?
That, my lord, has not been, my lord, my lord, we cannot say, my lord, because we are appearing for the deputy
What happened?
commissioner. The finance,
You have
finance,
taken decision in respect of three persons.
my lord, perhaps,
Just a
definitely,
minute.
my
You have taken in the decision in respect of three persons on 18/8/2007.
yes, my lord.
The application of this respondent was rejected, whereas two others persons were recommended for appointment in the SLC or state level, Joey, whatever.
My
it may be. What happened to that?
My
Whether
lord,
they have
that-
been appointed or not?
My lord, my humble submission before your lordship, my lord, the learned single judge has, my lord, look into that aspect, whether, my lord, that,
Just
but because, my lord, as
just
a
inform
DLC,
us, please inform us,
My-
what happened to those candidates whose recommendations were there for appointment?
my lord,
What happened to their case? Then we can understand that, yes, in the year 2007, the information was supplied by you
my lord.
to that finance department.
That aspect of the matter, my lord, that aspect of the matter, my lord, has to be, my lord, made query from the finance department. My lord, we as a deputy
Make your-
commissioner,
the query with the finance department, that is your headache, not of us.
my lord,
You inquire it from there and
my lord,
either
in the
place
said
it before,
circumstances,
otherwise
may I
no-
pray, my
there is
lord,
no
to
case for interference.
to issue notice, my lord, if your lordship,
at
my
all.
lord, issue notice in the said circumstances,
The
my lord,
poor
we can,
fellow
the
failed
finance
to
department,
get any favorable order
Because, my
since 2005, and now we issue notice to him, so he can again spend money on engaging a concept.
at least to the finance department, my lord,
Not at all.
at least to the finance department first, not only to ascertain, my lord, whether only to ascertain, my lord,
That
whether,
is
my
for
lord,
you to ascertain from the finance department, whether those persons were, what happened to application of those persons, whether those applications were dealt with, or those two persons are also deprived from appointment on account of non-communication.
my lord. Either their cases has to be rejected by the SLC or
Either or no either. You give us the information, exact information that is for
I will
you.
come again, my lord, by taking that individual, lordship may adjourn the matter for today, my lord. I will take that instruction
will
from the
note down
finance
this.
department. Lordship,
When it concept for the appellant has submitted that As a matter of fact, the communication dated 18/8/2007 sent by the Deputy Commissioner Kambu M has duly been received with the Finance Establishment B Department, wherein apart from the rejection of the petitioner's respondent's case, two recommendations were made for other persons were made for compassionate appointment. Stop. The counsel for the appellant has failed to disclose that pursuant to the communication dated 18/8/2007, on whether the cases of the other two persons were considered by the state level committee for compassionate appointment or not. And it counsel for the appellant takes some time to apprise this court about the status, about the fate of those two persons in whose favor recommendations were made by the district level committee to the state level committee. This तो after view vacation के बाद की date.
Oblige me.
The third week of April is whatever the fifth week of April. Fourth week. Fourth week.
Item 24.
Me, please, your lordship.
What happened to your application regarding regularization of temple and all?
My lord, that is under process, my lord.
That is under
That's
process,
under-
that the order is reasonable enough.
My lord, we are not aggrieved, my lord, at the moment by the demolition of the wall.
Then-
My lord, what we are aggrieved, my lord, is para 23 of the learned single judge's judgment, my lord. My lord may come to page 259.
Yeah. In
My-
addition to the above.
My lord. So we are aggrieved by that observation, my lord.
Read.
My lord. My lord, it says, in addition to the above, this court also finds it relevant to take note of clause 8 of the MOU dated 31st December 2014, wherefrom nothing could be shown that the petitioner had authority to construct any wall. The only authority which is reserved for the petitioner society is for maintenance of the common facilities as well as partition walls, sewers, drains, pipes, and appurtenances thereto in good tenable condition in clause 4 of the MOU. In clause 8 of the MOU, which have been quoted above, it would also show that the respondent number 2 still reserved the power to put up additional structures, flats, and other commercial buildings, facilities in the land shown as phase 2 area within the Games Village boundary, and also renovations, upgradation of facilities existing in phase 1 at its own cost. Therefore, the power as per clause 8 was reserved with the respondent number 2 for renovations, upgradation of facilities existing in phase 1. There is also a clear stipulation in clause 8 that roads, drainage, sewers, entrance, security, etc. of phase 1 shall be clubbed together with phase 2 if deemed necessary as per the assessment of the respondent number 2, meaning thereby the road in question upon which unauthorized wall have been constructed can be clubbed by the GMDA with phase 2 project. My lord, the only exception to this, to the use of roads, drains, sewers, etc., was that the said roads, drainage, and sewerage, etc., cannot be used for construction activities to be carried out in respect to phase 2. That too, when the same may affect the peace and tranquility amongst the residents of Game Village phase 1. Now, my lord may come to this opening clause 8 of the MOU. My lord may come to page 103.
That has been quoted by the learned single judge.
It has been quoted, my lord.
Page,
My lord, 103, my lord.
the internal page.
Internal page, my lord, of the judgment, my lord, was the beginning. My lord,
This 5,
yes, my lord.
internal page.
Para
5.
4 and 5. Para page 244, my lord. That the first party shall have the right to put up additional
The first
structure.
part,
First party is the GMDA, my lord, Guwahati Metropolitan Development Authority.
GMD.
And second party is the Resident Welfare Society. of the Games Village.
The appellants here,
Yes, ma'am.
the first party,
The first party shall have the right to put up additional structures, flats, other commercial buildings, facilities in the land shown as phase 2 area within the Games Village boundary, and also renovation, upgradation of facilities existed at phase 1 at its own cost. The second party shall have no claim over surplus land and project development as phase 2 of in land of 33.59 bigha. On construction completion of phase 2, part of the project, some of the facilities like roads, drainage, sewerage, and entrance security, etc., shall be clubbed together if deemed necessary by the first party. The second party shall have no objection to it. In taking up the construction works of phase 2, first party will, however, ensure that there is no unwanted or unwarranted interference like vehicular movement, which may affect the peace and tranquility. So and so, my lord. My lord, here, my lord, there is no, in clause 8, my lord, there is no provision for clubbing of the roads between phase 2 and phase 1.
there.
My lord, may come to page 103 of the agreement, my lord.
On completion,
My-
on construction completion of the
Phase 2 part. Some of the facilities.
two, phase 2 part of the project, some of the facilities like roads, drainage, sewerage, entrance, security, and etc. shall be clubbed together
Yes,
if deemed as a assessed by the first party, yes.
my lord, that is within phase 2. My lord, here what happened, my lord? My lord, we were sold the flats in phase 1. If my lord may come to the sale agreement and the sale deed, my lord.
You mean on construction and completion of phase, you said 1,
Phase 2, my lord.
phase 2.
Phase 2. Phase 2 is a separate project land, my lord. Though the owner was the same, my lord.
Part of the project.
My lord.
What do you mean by project?
My lord, of the
Project
phase 2
includes
project.
Phase 1 and phase 2, both.
My lord may come to, for a moment, my lord. My lord may come to the sale agreement, first of all, my lord. The sale agreement and the sale deed. My lord may come to page 76.
Yes.
My lord, clause 6 of the sale agreement.
Yes.
My lord, clause 6 of the sale agreement.
Yes.
My lord, that the GMDA only upon receipt of full amount of sale price, page 76.
Yes,
My lord. Was the sale agreement, my lord, clause 6?
just a minute.
Sorry, my.
Yes.
My lord was inquiring about the project, my lord. If my lord comes to page 87 of the sale deed, my lord.
Yes, earlier you mentioned page 76.
76, my lord, I was on the proportionate share of the land which is owned by the land by the flat owners, my lord. That is there in page 76, my lord. If my lord is on page 76, clause 6, my lord. That the GMDA only upon receipt of the full amount of sale price agreed shall grant, convey, transfer, assign, assure unto the purchaser free from all encumbrances the flat described in schedule 2 hereunder with full ownership rights over the same with all doors, windows, fittings, fixtures, both sanitary and electrical, all external and internal walls with proportionate share or interest in the title to the land, staircase, lift, all ways and passages, drains, watercourses, like together with benefits of all lights, liberties, easements, and appurtenances. This is the flat owners, my lord, have the proportionate share in all the common facilities. The roads would be a common facility, my lord, of which the owner proportionately are all the flat owners, my lord.
Yes.
What I would be on, my lord, is that the agreement, the MOU, was entered into between the GMDA and the Resident Welfare Society. The Resident Welfare Society is not the owner of the land. It is for welfare of the flat owners, my lord, for maintenance. It cannot give away the rights of the flat owners. The road, my lord, is the right of the flat owner. It owns proportionately all the 700 flat owners there.
Okay, fine.
My lord. No, my lord was.
How you are agreed by the construction of road?
My lord, the road is already there. It is within our boundary. What we are aggrieved by, my lord, is the observation by the learned single judge that the roads in phase 1, which is the project land insofar as our sale is concerned, they are trying to club it with that of phase 2. My lord, what we would be on, my lord, that issue was
project. The whole project consists of phase 1 and phase 2.
My lord, there's a
composite project. It's a composite project. It's not a separate project or altogether. It's a phase 1 and phase 2 means a composite project. And the facilities between the phase 1 and phase are to be connected. What's wrong in that?
My lord, in the sale deed, my lord, the project land is defined, my lord, as 36.41 bigha. That is the phase 1, not phase 2, my lord. What we would be on, my lord, is we are before lordships with a liberty, my lord, to agitate our rights insofar as the MOU and the others are concerned, my lord, before the appropriate civil court, my lord. For that, my lord,
open then why you have come here?
my lord, the reason, my lord, is that we would be.
You started a construction of a wall illegally.
My lord.
They served you a notice, you approached this court and then invited this order.
My lord, that has been demolished, my lord. I am not before your lordship against that demolition part. What I am against before lordship, my lord, is about the observation, my lord, in the paragraph which lordship had read. So that, my lord, if I go to the civil court, my lord, to agitate our rights, my lord, the observation will come in the way, my lord. That is the only liberty which I am praying before lordship. Let us establish our rights before the civil court.
You can clarify that at the moment, that the observation made by the land.
My lord, the MOU was not there, my lord, about clubbing.
Mr. Saika, and Mr. Chowdhury, what do you have to say to his request?
The overall composite project is of 70 bighas, lordship.
No, that's right. What we are asking is, what do you have to say about his prayer to approach the civil?
Without interfering with the learned single judge's order, let him approach wherever.
No
he likes.
interference. We can only clarify that the observations in that order is in the context of legality of the wall in question, which has already been demolished. That's all. Then he is not seeking any relief pertaining to the demolished wall.
That's what he said.
What is your clarification about this clause in the sale deed?
Sale deed, there is a
Consists of
subsequent
36
clause,
Bighas of some land. What he is?
clause 6. It has to be read with,
Not clause 6, he's referring to sale agreement.
page 76, clause number 6, Lordship.
Clause number 6.
He has placed just now.
That is not, in this, he has referred to this ownership of deed of transfer of ownership land.
Proportionate.
That is the normal process in all apartment holders, Lordship.
Here he said that the total land shown as 36 bighas
Yes, Lordship.
and not 70 bighas as you claim.
Next, because the overall project pays 100 and 224. Statement of areas. Proposed areas, total area of the game village FAR, pays 224.
Yes.
Proposed area, total areas of game village 70 bighas, total built up area so and so. Built up area in phase 1, 80,000 square feet. Built up area in the second phase, 1,51,000 or. So this is the overall project. In 2 stages, the project was done
2 phases.
in 2 phases.
My lord, if I may, my lord, this is about phase 2. My lord will see the developer at the previous page, my lord. The developer is simply-
What is the point in multiplying these litigations? It's a composite project, which is clear from the documents on
This
this.
itself shows that it's a composite project.
My lord may come to the previous page there. This is
Previous
for
page.
phase 2. Phase 2, not phase 1, my lord.
Previous page of what?
Of page 224, which the learned AG has pointed out, my lord.
Yes. Page 224.
My lord. Oh, my lord, here I have been served 2 pages. My lord. My lord may see the drawing, my lord. Existing development is phase 1. Within the drawing, my lord, the buildings which lordship sees.
Block 1, block 2, this one.
Yes, my lord. Yes, my lord. These are existing development within bracket phase 1.
This darkened area,
Not the darkened area, my lord, the light area with the drawings. my lord.
existing development.
Existing development.
Yes,
Within bracket phase 1.
yeah.
This is for phase 2, my lord. This was, my lord may see the approval date. That is in 2010.
So,
Approval date is 2010. Ours was, my lord, agreements were in 2007 and sale deed was in 2007, my lord. This was before the land was sold to us. The apartments were sold to us. Now, my lord may come to the sale deed, my lord, at page 87. What is the project land defined in the sale deed, my lord?
ultimately, it's a composite project and you can't say altogether separate
My lord,
area for your phase 1.
my lord, insofar,
If the project consists of this or mentioned about phase 1 and phase 2, it seems it's a composite project.
my lord may come for a moment for my satisfaction. My lord may come to page 87. What is the project land, my lord? The second paragraph in page 87.
Entire project is at page 100 and it is there in the documents also. 164. Hmm?
It has to be concluded because इसकी जमीन की ऊपर से नहीं तो phase 1 में जा ही नहीं सकता। हाँ? phase 1 में तो जा ही नहीं
This, in phase two, what you are proposing, this commercial or this, all this?
It
Phase
is a,
two mein,
it contains residential as well as commercial building.
commercial area, phase,
In the, and if I am not
This
wrong, there is a
project consists
clubhouse
of-
also.
phase one and phase two.
Phase one already, it was on the left hand side.
That yellow,
Yeah.
this yellow one.
Yes.
It is in both sides of the road. And this brown mark is phase two.
We have only highlighted the wall that was constructed and that, what is that? Where,
That has been,
that has been highlighted.
this
Yes, the end
road
of the road, my lord.
in blue.
Yes. That is the main. It is a common road in between phase one and phase two. And that touches the national highway.
Madam, that was not shown to us.
Yes.
My lord, that was that road which is being projected now to connect to the national highway. My lord, they already have separate roads, my lord, to connect to the national highway. My lord may come to page 87 for a moment, my lord.
Yes,
My lord, the second paragraph.
yes.
Whereas the GMDA is seized and possessed of a piece of land situated at Borsazai National Highway 37 under Moja Beltola, Guwahati, within the limits of Guwahati Municipal Corporation, which has been more particularly described in Schedule 1 hereunder, for the sake of brevity referred to as the project land. Now, my lord may come to page 96.
Yes.
Schedule 1, my lord, is land measuring 36.41 bigha, not 70 bigha, my lord. Here there is no mention.
Phase one only.
Phase 1, my lord.
Yes,
Now,
if the
and if my lord,
If the project already clarified that there would be two project phases,
my lord,
then it will be certainly there.
for that, my lord may come to the previous page, page 95.
Yes,
That is in clause 16 of the sale deed.
yes.
The GMDA shall have the right to put up additional structures, flats, other commercial buildings, facilities in the land shown as phase 2 area within Games Village boundary in phases, and the purchaser shall have no claim on the surplus land as described in the project land schedule. My lord, I cannot have any right over the land in phase 2. I understand, my lord. So similarly,
They've already clarified that there will be two phases.
Yes,
phase
my
one
lord.
and phase second in this agreement itself.
my lord,
Then
my lord, what we would be on, my lord, is that this 36.61 bigha in phase 1, that entire land has been sold along with the flats, my lord, to the flat owners who purchased phase 1 flats. My lord, what would be, my lord, what we would
One
be
more
on?
clause, lordship, that will clarify everything. Page 79, clause number 21. In her same agreement where he is told, clause 6, clause 21. The GMDS shall have the right to put up additional structures, flats, other commercial buildings, facilities in the land shown in phase 2. This is in his first phase agreement. Within the game village boundary in phases, and the purchasers.
the same provision which is in the.
Yes, yes.
Nothing.
So what we would be on?
You want an order on merit or what?
No, my lord, we would be constrained to approach the civil court for that a liberty.
Only that, you approach the civil court, you will not make any observation regarding whatever the learning thing that they said. You,
My lord, other parts
agitate
already-
before the civil court, they'll take it, follow.
My lord, but only that part, my lord, that the civil court will not be swayed by the observations.
That may further complicate the situation, not that.
Decide the suit on merit.
Yes.
Sorry, my lord.
Civil court will decide the suit on merit.
On merits, my lord. On merits.
That is-
That
After
observation
attempting
may
to
not,
argue the matter for quite some time, learned counsel for the appellant has submitted that he does not want to press this appeal, however seeks liberty for the petitioners to approach the, to avail appropriate remedy under the civil law. Dismiss with liberty as prayed for.
highly obliged.
My lord, the merit part, my lord.
If a proceeding is disputed, the civil court will decide the matter. on the case. If any such proceeding is initiated in accordance with law, the civil court may decide the matter on its own merit. It will be appellant, sir, petition.
My lord. Deeply obliged.
Item 25.
But I am seeking 2 weeks time to file my affidavit in opposition on behalf of the secondary education department. Finance has filed their affidavit, my lord. Reply has been filed.
You are appearing for 27 education department.
Well, I have appeal for the education, my lord. I appeal for the education department, my lord. I need to file my affidavit. That's what the,
Was this writ about?
my lord, we denied the advance increment for obtaining B.Ed degree to those teachers for whom now the B.Ed degree is already a mandatory qualification. They say that they had entered service without B.Ed, and therefore now that they have acquired the B.Ed degree, they should be allowed to have an advance increment. In the new ROP which has come into existence, my lord, the ROP says that no advance increment will be given for acquiring B.Ed degree for teachers. That is their basic challenge. So now the education department has to bring on an affidavit to show why that B.Ed degree will not be considered as a higher qualification or an advanced qualification for teachers for whom it is mandatory.
Here with regard to, my lord, the teachers who have been appointed prior to enforcement of the B.Ed degree as a compulsory qualification. We are the teachers appointed prior to that.
Yeah.
And
And you obtained the B.Ed degree later on.
later on. And those teachers who have acquired subsequently, and they have been given in thousands of cases, my lord, throughout the state of Assam. And some orders of this honorable court have also there, which allowed the directed to consider the case whether they have procured the B.Ed degree from the NCT recognized university or colleges and appointed prior to the cutoff date. Let them file, my lord, a date will be given, my lord.
Majumdar, for education department is 2 weeks time to file response on behalf of the education department. It's stop. Just after 2 weeks, you file by the next.
Yes,
hearing. Won't take much time.
A date, my lord, in the month of, my lord.
Whatever the date.
Date.
2 weeks के बाद की कोई date.
Obliged.
Supplementary list, item 35.
Kindly pass over for the time being, council is engaged in court number 10 and in another court.
Yes.
Kindly pass over for the time being,
Time being passed over. Suspension of the.
Pass on for the time being.
Pass over meter, item 10.
On the last occasion, I was directed to have instructions, my lord, from the respondent as to why the order has not been complied of till now. Well, my instruction is that, my lord, so far as the respondent herein, my lord, BP Bosumotari, he was a director in 2015. The order was passed in 2022, contempt petition filed in 2023. So I believe, my lord, this will have to be corrected by the petitioner by filing an impediment. I will provide him with the name, my lord, present director's name. Now, my lord, after getting the notice of this honorable court from me, they have already informed the, my lord, district authorities as well as the National Health Mission to provide all the information so that that order can be complied with. But some that technical point, my lord, he will have to take care of. I will provide him in the name of the.
What's the matter about?
My lord, petitioner was, my lord, appellant, my lord, as a petitioner, but filed petition, my lord. Because my lord, against the terminus, for his, my lord, unpaid salaries, my lord. But during dependency, my lord, he has come to know that he has been terminated, my lord. That termination order has been challenged, my lord. That termination order was challenged, my lord. But that in that case, my lord, Honorable Single Judge, my lord, passed order, my lord, not interfering the same. However, as there was no intimation of termination, my lord, so his, my lord, that period has to be counted for remuneration, etc. my lord.
Calmly.
What happened? Is representation, your representation has not been
Not
decided.
disposed of.
By way of this appeal, this contempt.
Yes.
You are seeking only that part where the remuneration up to 14 to 17. be
Yes,
paid.
my lord.
And you are not agreed by the dismissal order or termination order.
Already dismissed by honorable division bench, my lord.
My lord, actually,
Yes, my
the
lord.
contempt would have been filed before the learned single bench, my lord. Because, my lord, the order of the learned single bench has been, my lord, upheld by this honorable court. No further observation was made by this honorable court or any order has been passed by the division bench.
But at least you have to pay.
My lord,
the-
we'll do that, my lord. Only thing, my lord, the technical part.
Why this formality is that officer is not there and that.
No, my present officer was not aware, my lord. Now he has immediately, he has communicated to the authorities, lower authorities. He will do that, my lord.
Mr. Das, in these matters, finance is always a necessary party.
Yeah.
Your matter will get stuck up, without the finance. Why don't you understand these simple things?
And also, my lord, National Health Mission, my lord. He was working under National Health Mission. Now director has been directed. So he has sought for information from the, my lord, National Health Mission. We are waiting for that.
Several times it has been pointed.
You have already forwarded.
No, my lord, we have sought for information regarding this particular, my lord, petitioner from the district authorities as well as the National Health Mission. Only then the director can take a call, my lord. The present director, he is now acting upon, my lord.
Council, appearing for the health services, appearing for the director health services, Assam. Takes some time to complete his instructions. Whether the medical department has recommended the case of the petitioner for paying remuneration for the period running from 22nd of July 2014 to January 2017 to the finance department or not. List on and so 10 days.
Not to the finance department, my lord. Speaking order is to be passed by the director. Only thereafter, my lord, that this part will come.
Whether speaking order so and so takes some time to complete his instructions, whether the representation filed by the petitioner has been decided by the speaking order or not, and as directed by this court.
After 4 weeks, ma'am.
Not 4 weeks, only 2 weeks. इसका पता करने के लिए you are not required to take 4 weeks.
My lord, obliged, ma'am.
Obliged, ma'am.
Fast over matter 19.
You have argued many times and nothing else. Nothing. You were officiating, you can't get the salary, regular salary.
My lord, my case is that, my lord, when my right was there, my lord, my right was denied, my lord, and my junior was promoted, my lord.
That now she has retired already. You
Yes,
have
my
not
lord.
worked, you are working as a in charge, administrator in charge,
My lord,
as per this 49C.
my lord.
Fundamental rule 49C, no additional pay shall be admissible to the government admin.
Yes, my lord.
Employee who is directed to hold current charge of the routine duties of a airport is irrespective of the duration of the additional charge.
That was my prayer number 2, my lord. That was, I'm not pressing, my lord,
Then
for that, my lord. My prayer is before lordship, my lord, that when my right was there, my lord, I was denied in the earlier date. At least from that day, notional benefits may be given, my lord. I want to place two judgments, my lord, if some in, my lord. First, I'm reading, my lord, 2009, 16 Supreme SCC 248, my lord. Paragraph 8 and 9, my lord. May I read, my lord?
just
My lord.
So agreed by the temporary appointment or whatever the appointment of the Garima Sharma
My lord.
as administrator in charge, you filed a writ petition in the year 2011.
My lord.
In the year 2011, that writ petition came to be dismissed in the year 2014 as
That was
infectious.
infraction.
Infectious.
Yes.
In the meantime, this Garima Sharma was appointed as regular headmaster
My lord.
as she was in the merit number 1
Yes.
and you were on the merit number 2.
3.
Have you challenged that order at any point of time?
That was my
That
defect, my lord.
Yeah.
That was defect, my lord. I have to admit
It
that.
was
my lord.
defect, that is the material.
I have to admit that, my lord, but
Nothing.
my right, my lord.
You're right now in the year 2023, you
And-
came that I was senior to that Garima Sharma and I should be appointed at that time as a headmaster, a regular headmaster, headmistress. That can't be done.
And my lord, thereafter also, my lord, my lordship may kindly come to the judgment once again, my lord. The page 82, my lord. From that select list, my lord, another was appointed, my lord, after the 1 year of the select list. In my case, my lord, they are saying, my lord, that 1 year is over, so select list is over. Your right is gone.
Which year they have denied you?
My lord,
Admittedly, you retired in the year 2015.
yes, my lord. But in fact, my lord,
And you approached this court in 2023.
my lord,
What is this?
after retirement, my lord, for national benefits, I have filed this review,
2023 again,
my lord. Because
after 8 years.
earlier my prayer was, my lord, that I shall be appointed as the regular headmistress, my lord.
No, regular nahi. As a headmistress in charge.
My lord.
In
In
the year
charge, I was
2011.
in charge, my lord.
You were not in charge.
I was in charge, my
No.
lord. I was in charge, my lord. Later on, my lord,
Why you have filed this? Being agreed with the same,
my lord.
after retirement of the East Point headmaster, allowed Garima Sharma to be headmistress in charge of the said school, disregarding the seniority of the petitioner. Being agreed with the same, the petitioner preferred writ petition 5711 2011 challenging the order inspector of the school whereby Garima Sharma was allowed to be headmistress in charge in the said Majigam school. You have filed that petition for that only.
There are 3-4 round of litigation, my lord.
Only we are concerned with this petition as well as 2011 petition, 3-4
Yes,
rounds. It
my-
is nowhere mentioned, I think.
My lord. In the year 2013, my lord, that Garima Sharma was retired, my lord. My lordship, 2013, that Garima Sharma was retired and I took the in charge.
Headmistress in charge.
Thereafter, she retired in 2015. In 2 years, my lord, they never promoted me to the headmistress, my lord.
So you have approached the court at that time, 2015. Why you not come here?
My lord,
Matter you argued twice or thrice, nothing else. Every time you stop time, nothing.
lordship, in the year 2015, the WBC 776/2015 was filed to appoint her as a regular headmistress.
What
my lord.
happened to that?
That was also infructuous because she retired, my lord. Yes, my lord. So at least lordship, at this
No,
stage, my
where-
lordship may remand
You
the
want the
matter to the government, my lord.
dismissal of the writ petition as infructuous or on merits?
Infructuous.
This petition also.
This petition on merit.
You
my
will
lord.
dismiss it as also infructuous or nothing.
My lord, at this stage, at least my lord, lordship may remand the matter to the government to decide, my lord.
Please.
That can be done, my lord, only.
Nothing.
I leave it to your lordship, my lord.
This contract note appeal is filed by the petitioner being agreed with the order dated 1/3/2023 passed by the learned single judge in WPC number 3120/2016, whereby the writ petition filed by the petitioner seeking regular pay scale of headmistress and her appointment as regular headmistress from the year 2013 has been dismissed. Full stop. The learned single judge has refused to grant the relief of a regular pay scale to the petitioner for the post of headmistress while taking into consideration fundamental rule 49C. What is this rule called 14 fundamental rules?
49C.
The name of the rules,
Fundamental rules, my lord.
only fundamental.
Yes, yes.
FR 49C, bracket C, capital C.
FR 49C. क्या लिखा है? Fundamental Rule 49C, which provides that no additional pay shall be admissible to the government employee who is directed to hold current charge of the routine duties of a higher post, irrespective of the duration of the additional charge. Admittedly, the petition, the appellant was never appointed as regular headmistress, and was holding charge of the duties of the headmistress. Full stop. Taking into consideration the said fact, we don't find any illegality in the order passed by the learned single judge, whereby relief of grant of regular pay scale to the appellant for the post of headmistress has been denied. So far as regarding the claim of the appellant for issuing a direction for appointing her as regular headmaster from October 2013, a regular headmistress from October 2013 is concerned. It is noticed that for the said relief, the appellant has approached this court only in the year 2013. 2023, where she retired. Whereas she has already retired in 2016. In the year 2016, whereas she attained the age of retirement in the year 2015. Stop. Taking into consideration said fact, we are not inclined to grant the relief of directing the respondents to treat her regular headmistress since year 2013. In this, the same is therefore dismissed.
Obliged.
Fast meter 35.
May I please, your lord?
We filed my affidavit in this case, madam. We have filed affidavit in this case. Yeah, our case, madam, basically, madam, court martial was held in Manipur, madam, and he is in jail in Manipur, madam. And so far, we raised the jurisdiction point before. My lord, the unpost tribunal is for age date, my lord.
Armed tribunal is situated in.
In
there.
Guwahati, my lord, in Guwahati.
Then certainly this petition is going to be.
Because my lord, this we are, all respondents are from the Manipur and the other state, my lord.
Huh?
All respondents are from the other state, my lord. Manipur and.
You are appearing now.
What?
You are appearing for all the respondents of
Yes, well.
Manipur state.
Yeah, I'm for India.
Yeah, what's wrong with that?
And my lord, so far this, here, they really application is concerned, my lord. The bail application, my lord, is page 240, 228, my lord. In this case, there is no such ground for bail, my lord. The petition filed before the armed forces tribunal, my lord.
He is sentenced for how many years?
4 years, my lord, but
And he is in jail from, his custody since
14 September, my lord. 14 September.
14 September
Yes, 2023.
2023.
Yes.
So almost
6 months.
around
But allegation,
6 months,
but allegation,
6, 7 months.
allegation is my lord, allegation, the fourth charge, my lord. He's maintaining foreign contact with France, my lord. And my lord is,
Ultimately, the punishment is of 4 years only.
yes, that is, that.
Then what remains?
And he is also,
Even
my lord,
if
related
the
to
allegations are so serious, then why this punishment is only of 4 years?
this page 9 of the present petition, search for, my lord, section, this maintaining foreign contact as a friend on the Facebook account. By having 39 foreign national as contact in his phone book, maintaining 2 phone calls from foreign international subscribed and dialing numbers so and so and so. My lord, this and my lord, this my lord, this one charge was there. My lord, this suspected, my lord, with PFI also.
Actually, we had an altercation with the staff of Taj Mahal. What is the allegation that he had, along with his friends, had an altercation with the hotel staff?
Yes, my lord.
So you put him behind
No,
the
my
bar?
lord, thereafter, as per complaint of the hotel, my lord, there's the intelligence, they come, my lord, and thereafter, my lord, there's after 2021, my lord, when everything was, my lord, this investigate, my lord, it is found, my lord, these are allegations. In his, my lord, accounts also, some money come from the outside this country, my lord. And my lord,
This is not true, my lord.
Huh?
and one of his, my lord, trust is there, as per his, my lord, my lord, he submitted his one trust, my lord, in Silsar, my lord. It was also not found, my lord. There is an account taken the trust also, my lord. These are the, my lord.
उसके अकाउंट में कुछ पैसा है तो उसने एक्सप्लेनेशन में बोला है कि ट्रस्ट वो बात ही हो जेल में
That it is, how they deny, the tribunal has denied the suspension of sentence.
My lord, there's the grounds, there is no grounds for such melody, there, melodies, filed, petition filed before this melodies, tribunal melodies.
15(3) clearly says the tribunal
I
shall have
understand.
power to grant bail to any person accused offence in military custody with or without condition necessary, provided that no accused person shall be released if there appears reasonable ground for believing that he has been guilty of offence punishable with the death or imprisonment of life. Only in that case.
Yes,
it
I
can refuse.
understand.
The tribunal can refuse.
But there is no ground made out by the petition, my lord, they placed on 428, my lord.
What ground?
Accordingly, my lord, this order was passed, my lord, this placed on 437. The application has been filed for suspense of remaining sentence of the applicant entirely on the ground that the trial was barred by limitation.
Yeah.
Electronic items are seized, were given to the forensic authority after 9 months. Payment of bank account were received from friends who have been deposed during the course of trial. However, learned counsel for the appellant has not been able to convince the court on any of this point.
This is what the order is.
Yes,
Very well reasoned order. Very well reasoned. Literally, it can't be interfered. This is the order. Okay. The writ petition is filed by the petitioner being agreed with the order dated 9/10/2023, passed by the Armed Forces Tribunal Regional Bench Guwahati, whereby the application filed by the petitioner for suspending the sentence awarded by the court martial, awarded in the court martial proceedings dated
My lord, 31/7/2023.
31/7/2023. Stop. In the said proceedings, the petitioner was awarded 4 years rigorous imprisonment.
Simple
Section 69 of the Armed Act.
While in view of the order passed by the in the court martial proceedings, the petitioner is convicted for the offense punishable under section 69 of the Army Act 1950, read with section 12 in bracket
13(2).
Sorry, 13 in bracket 2/13 bracket 1 bracket capital E of the Prevention of Corruption Act 1988 and sentenced to be reduced to ranks and suffer simple imprisonment for 4 years and to be dismissed from service. Full stop. The tribunal, the tribunal has rejected the application for suspension of sentence while order dated 9/10/2023, simply by observing that learned counsel for the appellant has not been able to convince this court on any of the points advanced for suspension of sentence. Full stop. Having heard the learned counsel for the parties and after going through the material, after going through the record of the court martial proceedings and particularly taking into consideration the fact that the appellant is in custody, the petitioner is in custody since
14th September, my lord.
14th September 1993.
2023.
And the sentence, total sentence awarded to the petitioner is 4 years. We deem it appropriate to allow this writ petition and direct the
4 years of imprisonment. 4 years of imprisonment. Sentence is 4 years of imprisonment.
4 years of imprisonment, simple imprisonment. Direct the
Suspension of sentence.
And ordered the suspension, and it is ordered that the sentence awarded awarded to the petitioner in the court martial proceedings is suspended till pendency of the appeal before the Armed Forces Tribunal. Till pendency of the
During pendency of the
application number 36 of 2020. Sorry, the OA number bracket में capital A 24/2023 pending before the Armed Forces Tribunal Guwahati. That what is the Armed Forces?
It will be Camp Imphal. Guwahati
Yes.
bench Camp Imphal.
This was my lord's camp circuit.
Armed Forces Tribunal Regional Bench Guwahati.
Guwahati, my lord.
Provided that the petitioner shall furnish a
What is the?
bond, a personal bond of rupees 25,000 along with two sureties of likewise amount to the satisfaction of the general commanding headquarter 57 Mountain Division Signal Regiment, Limahong, Imphal. ये respondent number 3 का order.
General Officer Committee. This petition is disposed of.
Highly obliged, my lord.
For hearing, item 26.
Lordship, this is regarding the pay scheme.
हो गया order कर दिया.
No, there is one small impediment in
You are
between.
sure, you are sure
No,
on that
no,
date
Lordship,
court, okay, I'll do that.
No, Lordship,
I'll get it done.
no, there is something, Lordship, which,
There is nothing. You get it, get the order.
in that case, Lordship will pass order because I cannot.
Why?
I'm giving this, Lordship.
मौके तो दीवाने की.
You already have.
No. He was.
Hey, no, that is already answered. This was, there.
You have admitted in, on that day. you
Lordship,
have
I,
admitted in so
in
many
fact-
words.
in fact, Lordship, yes, but when I had taken it up with the authority in the Tejpur University, Lordship, there is because I cannot override the UGC. And this was there, Lordship, in the affidavit in opposition filed by us, in the writ petition also. Though a typed copy, I got the originals here. So this,
Yes. Okay.
at page 18. So this will, in my, yes.
Yes. You supplied the copy?
Yes, it is already part of the record, below.
Both this 8th April and.
This is
20th of
the,
September.
second letter has been annexed as a annexure in the affidavit.
Which dated?
That is 30th September 2011.
That has already been.
that 30th September 2011 is already part of the record.
Yes,
It is at page 89. And
Yes. Reiterated, reiterated, it's the same thing.
This 30th September 2011 is already part of the record in the writ petition.
Yes.
That was already in the writ petition. And basically, my lord, of course, my lord, after he completes.
Lordship, his submission was, Lordship, that he would be falling in the category of serial 26 at page 66.
Yes.
Because his scale was 18,300, that is the
Yes.
in spite of 12,000 to 18,000, he was given 12,000 to 18,300. Therefore, it was his submission that he would be falling in the next category of
8700.
yes, Lordship. Now, that this scale was anomalous, 18,300. That was taken note of, and in fact, it was taken up with the UGC, who in turn has taken it up with the ministry. So, for the standing instruction of the ministry, Lordship, that the university cannot go ahead and unilaterally give him that skill. And that scale was anomalous. That has been taken note of by the university, UGC and the ministry, Lordship. But And it that- is there. Yes. The scale still holds the field. This one, It was not rectified. Anomalous scale, you are saying. No. See, the point here is very simple.
Yes.
And on a very short campus.
Yes, Lordship.
The pay scale drawn by the petitioner prior to revision was, the higher ceiling was 18,300,
Yes, Lordship.
correct?
Yes, Lordship.
So if you go by the schedule
Yes, Lordship.
pertaining in
Page 66.
page 66, pertaining to the rules 3 and 4,
Lordship.
it clearly spells out what would be the corresponding pay band and what would be the grade pay.
Yes,
So
Lordship.
it's a question of simple arithmetic here.
Yes, Lord.
So if this is the pay scale, this will be the revised pay scale. How can anybody alter this or modify this? Anybody in the department or in the section has no scope to interpret and modify this. If there is any anomaly in this table, then the table has to be modified. It can't be that the table remains as it is, but somebody disagrees with the scale. That's not permissible. That's the question we asked you.
No, that is why, Lordship. University on its own cannot. If Lordship directs,
No. cannot.
Because this is because university is bound by the directions given by the UGC. And it was placed before the
Who is for the UGC?
Mr. Chamua had appeared earlier, Lord.
Where is? Sorry? Oh. जो इनका इसमें है तो उनको फॉलो करना पड़ेगा। ये कह रहा है कि ये कह रहा है वो सही है लेकिन UGC बोलेगा तो आप बोलिए तो इसके लिए तो UGC को ही प्रश्न नहीं पड़ेगा।
We'll fix it on 24th. 24th update.
No, sure.
Ask the UGC council, he'll clarify the situation. But, Chaudhary, once you assured this court, then
Lordship,
now
in
you are
fact,
resigning, it's not.
Lordship, what has fallen from your Lordship, I do agree. But
Do agree, then
but-
get it done.
no, Lordship, I cannot. As a university, I cannot. I am bound by the instructions of the UGC law.
You yourself has admitted, yes, this is an anomaly
Lordship,
and I'll get
yes,
it
Lordship,
clarified. But
What has fallen, I do agree with your Lordship, but then I cannot override the UGC Lordship. Yes, sir.
Item 27 and 28.
Your Lordship, I'm appearing in item 28 virtually.
I appear for the petitioner. Please to fix this matter. I your Lordship's notification of first that your Lordship will be taken up only urgent matters. I thought it might not be taken up.
Your voice is breaking. We can't hear any. We can't follow what you're saying, Mr. Sinha.
Yes, sir.
Your network is erroneous or there is some problem. Your voice is breaking. We are not able to follow what you're saying. Mr. Pradumna Sinha.
Is appearing for petitioner or what?
Petitioner, my lord.
In which case?
Item number 27.
Item number 27.
Your Lordship, item 28 is a linked case. I am for the petitioner in item 28.
Yeah, I understand.
Appear.
You are seeing it. What to do, Mr. Debate?
Lord, in fact,
You are being led by Mr. Sinha.
yes, my lord.
He's a senior counsel.
No, my lord. He's not a designated senior, my lord, but I am led
No,
by.
but what to do? His arguments are not coming through. So, Mr. Chaudhary, sorry, we are unable to hear the arguments of one of the councils.
Your Lordship, if your Lordship permits, I am very happy to proceed.
No, we can't. There are two matters. How can
All
we-
right, your Lordships, all right.
And sometimes this VC business may be a little difficult in these reasons.
Am I audible, your Lordships?
Yeah, you are very much audible, but.
You are audible.
Senior counsel is not audible.
I see, I understand.
He is in fact paused. His photo is even paused.
There is a lag in the internet.
Where is he?
My lord,
Where is he?
in Kolkata.
Kolkata.
On 30th April.
30th.
Oh,
Item 31.
Wait, please.
Well, pursuant to the previous order, my lord, I have filed the affidavit as required, as directed by the last order, my lord. I have
Photo काढा घेतात. Order to put it. Order to put it. Last order. The synopsis made by my learned friend, my lord. Date wise, if the lordship wants. Otherwise, the order dated 3/10/23 is very clear. Order passed by your lordship. 3/10/23.
Yes, where is your affidavit?
Affidavit I have filed on, my lord. On 21st of March, my lord.
It starts from which page?
Please, my lord, 220.
22?
220, my lord. 220.
220.
Yes, my lord.
Hmm, 234.
234. Narayan Komar.
Yes, my
IAS.
lord, Narayan Korman.
There is no
Yes, my lord, there is no recorded minutes at such, my lord. But
indicating that her services were illegal or terminated at any point of time.
yes, my lord, there is no,
Then what remains?
only thing is that, my lord, on the basis of the scrutiny of the document, they prepared a list. In that list, her name was appeared, my lord.
What basis? When her services were not at all terminated.
Yes, my lord, not
That
terminated. But she
her
herself
services has
participated.
never been terminated as a
that-
teacher. And now you have appointed her as a tutor. The division bench has already. We are prima facie that the respondent appointment order dated has not been reversed illegality. The recalled the legality of the order dated 30th of January, appointing her afresh as a tutor on the fixed salary is by itself seriously questionable. Under what circumstances?
But the thing is that, my lord, from 91 to 2001, my lord, there was a huge scale of illegal and irregular appointment in the state, my lord. And to overcome that situation, pursuant to the order of this honorable court, my lord, a screening committee was constituted. And in that screening committee, my lord, the petitioner herself participated, my lord, since she was also not given the
No, she
salary.
participated and you appointed her as a tutor, but her appointment as an assistant teacher has cancelled at any point.
No, my lord, not cancelled.
So then how you can appoint her as tutor?
She will have to be deemed to be in continuous. It has to be in continuous.
And till date, she is discharging the duties of teacher. Yes.
Like court directed, just check whether she is continuing. If she is continuing, you pay her salary. This is what was the order of the court.
Report of the direction of
That
the.
is the order of the court. Then thereafter, they filed review. It was dismissed with cost of 50,000 rupees. Then we filed a contempt. Contempt also, your lordship will see the order at, I think 205. There also that order is there. Then thereafter they file review petition, writ appeal.
They have deposited the amount of rupees 5 lakhs.
5
and
lakhs
something.
that has been paid to her. And they have to pay the balance amount after the Supreme Court, two judgments I have annexed, one page judgment, your lordship will can see. Other judgments are there, page 208, your lordship will can see. This is the division bench judgment of this court. Just para 13 and 14, their order of termination was not communicated. 208.
Iqbal Ahmed Ansari.
Yes. It open to. 211, sorry, my lord, 211. Para 13 and 14. Then your lordship will kindly see 215. One page judgment of the court. Page 215 and para 5. Page 217, it says tantamount to take beggar from them. So taking service, you don't want to pay.
In contempt, what happened?
Contempt order is there, my lord, your lordship, I think it is.
What happened after that contempt?
Now, after that, they file review petition, then file writ appeal,
And that contempt is still pending.
still pending.
There is a stay of,
2019, January two
there
thousand
is a
nineteen.
stay of the order of the land and
Here
single
is writ
judgment.
appeal.
Stay here.
In the writ appeal. Yes, madam.
Writ appeal, after they order in contempt, they file review petition and writ appeal.
That,
Contempt.
now this single judge judgment has been stayed.
Yes,
Yes.
madam.
Last year, affidavit के बारे में.
Okay. This writ appeal is filed by me. States being agreed with the order dated 22nd of January 2019 passed by the learned single judge in WPC number 1728/2015, whereby the learned single judge has disposed of the writ petition filed by the petitioner while issuing direction to the elementary education Assam to verify as to the respondent has been discharging her duties as assistant teacher of number 1131 Jal Khana LP school presently, and upon such verification, if it is found that the appellant is indeed discharging her duties in the said school as an assistant teacher, her salaries, both area and current should be paid. Full stop. It is further directed that the entire above exercise be undertaken within a period of 45 days from the date of receipt of certified copies of the order. Full stop. The brief facts of the case are that the respondent was appointed as assistant teacher on a section vacant post in a recruitment process initiated in the year 1997. She was appointed as assistant teacher at number 143 Paroma Nimna Bunyadi Vidyalaya on 4/12/1999. She was paid salary pursuant to the said recruitment up to April 2006. However, later on, the respondents have stopped the payment of salary to the respondent. Full stop. Being agreed with the same, the respondent has approved this court by way of filing the writ petition, which came to be disposed of by the impugned order. Full stop. It is noticed that during the pendency of this appeal, the Standing Council for the Elementary Education Department has drawn attention of this court regarding the order dated 30th of January 2021, whereby the respondent has been accommodated afresh as a tutor on purely temporary basis on fixed salary of rupees 10,800 per month. Full stop. This court, while taking note of the fact that the respondent's appointment as assistant teacher while order dated 4/12/1999 has not been reversed oblique recalled at any point of time, then the action on the part of the respondents of on the part of the appellants or of appointing her afresh as a tutor by the order dated 30th of January 2021 is highly questionable. Full stop. While observing this court, a coordinate bench of this court has granted opportunity to the counsel for the appellants to place on record the minutes of the scrutiny committee meeting in which the case of the respondent was considered, leading to the issuance of the order dated 30th of January 2021. Stop. Thereafter, on Seven 2024, the counsel for the appellants has submitted before this court that the screening committee has found the initial appointment of the respondent number 1 writ petitioner to be illegal. Considering the same, this court has directed the education bracket my elementary department to file an affidavit of this effect, to this effect, and pursuant to that affidavit of the secretary to the Government of Assam Department of School Education is filed. In the said affidavit, the deponent has stated that since more than 12,000 incumbents belonging to category of illegal / irregular teachers appeared in the screening process before the screening committee is headed by the divisional commissioners in their jurisdiction, no minutes of the meeting were prepared, and therefore the same is not available. Full stop. It is noticed that in the said affidavit, there is no whisper about the reversal / cancellation of the order dated 4/12/1999, whereby the respondent was appointed as assistant 4/12/1999, whereby the respondent was appointed as assistant teacher. Taking into consideration the fact that the respondent was appointed as teacher on 4/12/1999 as assistant teacher on 4/12/1999, and this said appointment has never been cancelled. The fresh appointment of the respondent as a tutor wide order dated 30th of January 2021 cannot be sustained, and the same is liable to be set aside. Full stop. At the same time, we don't find any case for interference in the impugned order passed by the learned single judge, whereby a direction is issued to the Director Elementary Education Assam to pay the salary, to pay the arrear and the current salary of the to the respondent on the for the post of assistant teacher after verifying the claim, the said claim. Full stop.
It is submitted that he is continuous.
It is submitted by the counsel for the respondent that till date, the appellant is serving as still she is as assistant teacher. Till date, the respondent is serving as assistant teacher. And this fact has not been disputed by the counsel for the appellant. Stop. In such circumstances, we don't find any case for interference. However, a month time is granted to the appellants to comply with the order passed by the learned single judge. Impugned order passed by the learned single judge. He made it clear that if the arrears of the salary are not being paid within the period of 30 days, the respondent shall be, the appellant shall be liable to pay interest at the rate of 9% per annum on the arrears of the salary.
Then only one more observation, Malad. As regards,
Cost lagani rahi.
Malad,
This is the only observation that we have not imposed the cost. And otherwise, there is nothing.
no, in the review petition, there was a cost imposed by the land single just questioning our bona fide, Malad.
You have to pay that.
But because we have filed a review petition only because that's process of screening.
You are agreeing for this enhancement of the cost, we can do that. Otherwise, we are not going to interfere. 50,000 cost. Cost was imposed. How much cost was imposed?
50,000, Malad.
50,000. So we'll enhance either to 1 lakh or be satisfied with the 50,000. Yes.
Item 32.
Oblige, Bakshi.
Madam, the judgment imprinted is page 118. Starts at 118. The basic, in nutshell, the fact of the case is that, my lord, the appellant was working as a constable of Assam Police. And departmental proceeding was initiated against him.
Compulsory retired.
He has been compulsory retired.
What wrong in that?
Then, my lord, I am coming to that inquiry report was not supplied to him prior to the
That's
imposition
why
of the
only
penalty.
the learned single judge has said that they supplied the inquiry report and initiate the inquiry from that day.
Yes, that extent is, my lord, law is there. But, my lord, the kindly come to the last portion of the imprimed judgment, my lord.
They would,
Para nine.
the single judges refused to interfere with this termination order or voluntary retirement order.
To that extent, my lord, the law of ECIL is
But
rule play.
remains.
My lord, I am coming to the last paragraph, para 9.
Yeah.
However, we are clarifying the ground argued by the petitioner, the presenting officer has also acted in which after perusal of the material is rejected, the said ground shall remain foreclosed. And the petitioner may submit his reply by taking any other ground. And when I will file a representation against the inquiry report, that is a legal ground as per the law 2000.
Yes, now that the presenting officer is not there.
There.
Not there.
Not there.
Then
Then, my lord,
new presenting officer will come.
no, I am to submit a representation against the inquiry report.
Against the
Inquiry report. That is the findings of the honorable and direction is there. I'm coming to the para 7, page 121, para 7. By referring to the statement in paragraph 7, Mr. T.C. Chutia, learned additional senior government advocate, raises the contention that it is an admitted position of the petitioner that the inquiry report was not furnished. Mr. I.S. Srikia, learned counsel for the petitioner, state that he has incorporated a correction in his own copy to the extent that paragraph and petitioner had the inquiry report was submitted but not furnished to him. A further contention raised by the no adequate time was given to the petitioner to give a reply to the inquiry report in as much as the impeachment order was passed on the same day. We are of the, it is agreement with the I.S. Srikia, learned counsel for the petitioner on the aforesaid contention that inadequate time was given to the petitioner to give a reply to the inquiry report. Accordingly, the matter stands remanded back to the disciplinary authority to proceed from the stage of giving adequate time to the petitioner to give reply to the inquiry report And based upon the any reply to that may be given, the disciplinary authority may pass its own reasoned order. The order of removal from service dated 11/12/2014 imprint in the writ petition is not interfered with at this stage, but it is provided that whatever order disciplinary authority may pass after allowing the petitioner to give his reply, inquiry report, the same shall be. Then, my lord, para 9, however, clarifying that ground argued by the petitioner that the presenting authority had also acted as inquiry officer after perusal of the materials as rejected, said ground shall remain foreclosed and the petitioner reply other ground that the aforesaid ground. Presenting officer was not appointed, and the law of 2018 7th Honorable Supreme Court in the case of the Union of India versus Ramlakhan Sharma.
Now, this inquiry report is already there. You have to file a representation against that inquiry report. What it means now?
My lord, para 9, my lord, I am to take this ground also. It is a legal ground, my lord. To that extent, if your lordships interfere. Para 9.
How this court has come to the conclusion that after going through the material that the presenting officer and this inquiry officer are the different persons?
No. No presenting officer has happened.
Yes, madam.
Lordship, may kindly come to page number 107, Lordship.
107.
Of our affidavit, Lordship, respondent number 5. Starting from 106, paragraph 8.
Read.
Lordship.
Read.
In this connection, the department further begs to state that on trial of the departmental proceeding number, so the inquiry into the DP was initially assigned to the additional SP headquarters depot and subsequently entrusted to Miss MS Ninkodai Simsong, APS Deputy Superintendent of Police Depot, who completed the inquiry into the DP. And on the light of the evidences, came forth the inquiry officer submitted a detailed inquiry report on 11/12/2014. On the light of the findings with the gravity of the offense, the applicant had committed on the minor girl, a major punishment was inflicted on the then UBS Tribunal Habibur Rahman in Laskor by awarding punishment with compulsory retirement from the government service right order dated so and so by the disciplinary authority come the appointing authority after observing all necessary formalities. Moreover, on initiating the DP, the applicant was asked to submit in writing amongst other whether he was prepared to inspect the documents which have relevance with the matter under inquiry, etc. But the delinquent did not avail the scope. It was the petitioner himself denied to inspect the documents, Lordship.
Himself?
The petitioner himself denied to inspect the documents of the proceeding, Lordship.
The allegation include the name. Where did you read?
Page number 107, Lordship.
107, yeah.
Lordship.
Connection with the department further begs to state that on all of the department proceedings, the inquiry into the DP initially assigned to additional SP those to so and so. To complete the inquiry into them, the light of the evidence came for here detailed question regarding not inspection of documents.
Lordship.
The question what he is raising that the presenting officer and the inquiry officer is the same officer.
No, Lordship.
That is his own contention. That is the only contention which he is raising.
Lordship.
So the presenting officer and the inquiry officer is one of the are the same persons or the different persons?
Different person.
From where we
Record was called for, my lord. On a earlier date, my lord, the date,
Could have produced before your Lordship.
record was called for.
record for what?
Called for. That is the, my lord, the order dated 17/5/2023.
Where is that record?
Yes,
Days to
Lordship.
keep record available. 7 days to keep the record available. Okay.
Item Keta cell 33 and 34. No, sir, lawyer doesn't look at it. You are appearing in 33.
Yes, 33 and 34.
Karna,
33 and 34.
want to argue? No, no.
It can be fixed after vacation also, my lord.
Fine, I have objection, my lord.
Oh, no.
For the department.
In the wing, okay.
Because it become infrastructure, my lord.
Okay, fine, we'll hear it.
Yes.
Then इनके बाद में
Complete one. Hey, Harry, it is yours.
একটু লব না মানে ঘুরাই দিছে এখানে কইছো ঘুরাই দিয়েছে এখানে কইছো একটু ঘুরাই দিয়া আছে রেকর্ড রেকর্ড তো কই দিও রেকর্ড তো কই ऑर्डर गलत है नहीं सबसे बड़ा ये ग्राउंड है पहला कि एंट्री का ओके फिर पेनल्टी को पुराना पेनल्टी जो रिमूवल की वो रहेगा मैं ऑर्डर उसको रिप्लेस करता हूँ वो ऑर्डर एक बार दे दिया तो एक और रिप्लेस तो उसको गलती तो नहीं रिटायरमेंट ना
What is the original penalty? Removal or compulsory?
Compulsory retirement.
There was no order of removal from service.
No.
Then why it has been mentioned in the paragraph 8? Paragraph 8, line about 4 from the bottom, page 122. Order of removal from service dated 11/12/2014.
No, my lord, it is not
Wrongly written.
wrongly written. my lord.
Wrongly written,
Wrongly written. It's not removal from service.
not
My compulsory.
compulsory.
So the single judge has rejected your contention that inquiry officer and presenting officer were the same.
Yeah.
You have to establish that.
That is without consulting the record of the disciplinary proceeding.
Record was placed before the learned people. sir.
Record will say whether there is presenting officer brief is there or not.
Yeah.
If the presenting officer is appointed, presenting officer is required to submit a brief also.
What the presenting officer is to do is not something you can say.
Well,
You can only raise a question if the presenting officer also acts as inquiry officer.
yes, ma'am.
Whether he presents a brief or doesn't, that's not something you can.
Yeah.
You can rely upon. That's not, that is for them.
That is why, my lord, learned single judge in paragraph 5 of the judgment, my lord, is categorically written in the last line of paragraph 5. In the instant case, as no material is available to arrive at a conclusion that the inquiry officer also acted as a presiding officer, the said proposition of law in paragraph 36 of Ram Lakhan Sharma.
In fact, there is no appointment of the presenting officer as such in this record.
Record no presenting officer as appointed,
No presenting.
No,
officer.
not appointed.
not appointed.
Yes.
Then my
how
lord,
you can claim that the presenting officer and the inquiry officer is the same?
then my lord, if not presenting officer, inquiry officer led the question and the
No, that can't be. Now, whatever your specific contention is this, that the inquiry and the presenting officer are the same.
Same.
That is not reflecting from the record.
then my lord, the presenting officer should have their presenting officer signature also is there. The daily order sheet, there must be signature,
What presenting officer signature?
must be there.
On
If
what?
it is daily order sheet,
Daily order sheet.
yes.
When the presenting officer is not appointed, my lord, the question of,
He has never been appointed, sir.
Yes, never been.
Why he appoint anyone?
No. Only inquiry officer appointed, he led the question, he led the question in chief, examination in chief and cross both.
That's another. That is the job of the inquiry officer. Presenting officer is someone who present case on behalf of the department.
My lord, the presenting officer judge, the inquiry officer to remain as a judge in the inquiry proceeding. He used to observe this and he may question. It is not the, that the, my lord, this is, I am reading from this paragraph, my lord, of the 2018-7 ECC, Union of India versus
Yes.
para 33. If the inquiry officer conducts a regular examination in chief by leading the prosecution witness through the prosecution case or puts leading question to the departmental witnesses pregnant with the answers or cross-examines the defense witness or puts suggestive question to establish the prosecution case of the employee, the inquiry officer acts as a prosecutor, thereby vitiating the inquiry.
and paragraph 34 in the said judgment, my lord, it is categorically stated that we fully endorse that the principle as enumerated above. However, the principle have to be carefully applied in fact situation of the particular case. There is no requirement of appointment of presiding officer in each and every case, whether statutory rules enable the authorities to make an appointment or are silent. When the statutory rules are silent with regard to the applicability of any facet of the principle of natural justice and applicability of the principle of natural justice, which are not specifically excluded in the statutory scheme, are not prohibited.
Mr. Sharma. Mr. Nath, two things. The concept is that the judge and the prosecutor should not be the same. That doesn't preclude the judge from asking questions. So the inquiry officer can always ask questions. That is not a problem. He has not acted as a presenting officer. At least that to sustain that kind of a view, there is nothing on the record. Number one. Number two, if the order of the learned single judge is upheld, and on your second contention that there was no inquiry report furnished to you, then the penalty of compulsory retirement will have to be set aside. It will be open for them this time to issue an order of penalty which can be higher than that also. Dismissal from service also. That is a risk you will run.
Yes, my lord.
Think about it.
My lord. If I submit my representation, that
Because looking at the allegation, one would have thought that compulsory retirement is a softer option. But if we set it aside, we'll make it open that they can pass any order of penalty.
to that extent, my lord,
Considering the more particularly, my lord, considering the charge
Then
level.
it could be even dismissal.
no, my lord, that is there. But if I submit a representation, the inquiry report officer, to that extent, my lord, I can take all the legal plea.
All the pleadings except this, the court has kept it open. You can take whatever the ground
That is
except this.
except this, but that is what my, it is a legal issue.
The legal issue.
That
whatever
on fact, if I
that
say,
is-
if I am entitled to raise also.
सवाल पूछ रहा है वो कर सकता है
There is no cross-examination found in the record.
There is no cross examination even and there is no appointment of the presenting officer.
No.
Okay.
To that extent, I may be taken that ground in the plea because.
For what? When there is no, there was no appointment of the inquiry officer, how can you take this ground even?
My lord, that is what it is a-
Presenting officer, then how can you take this ground even?
my lord, would not, if not, because the Assam Discipline Appeal Rule 7, Sub Rule 6, there is a provision of appointment of the presenting.
That may be. Why you have not raised this question before the learned single judge? You have simply said that the presenting officer and the inquiry officer are the same.
Now, my lord, in my representation, I may be may be allowed to
Sorry.
take this ground.
Nothing.
So that, my lord, in representation says how I've been prejudiced. I'll say the disciplinary authority that how I've been prejudiced due to non-appointment of the presenting officer.
This intra-court appeal is filed by the petitioner being agreed with the order dated 12/12/2022. Whereby the learned single judge by disposing of the writ petition filed by the petitioner has granted liberty to the petitioner to give reply to the inquiry report with the further direction to the disciplinary authority to pass its own reason order. Stop. Simultaneously, the learned single judge has refused to interfere in the order dated 11/12/2014 impugned in the writ petition whereby the appellant was compulsorily retired from the service after a departmental inquiry. Stop. The learned single judge has observed that the order dated 11/12/2014 retiring the appellant compulsorily will remain subject to the fresh order passed by the disciplinary authority. Stop. The learned single judge has further clarified that the ground taken by the appellant to the effect that the presenting officer has also acted as inquiry officer be treated as foreclosed and the petitioner can submit his reply by taking any other ground other than the aforesaid ground. Stop. Learned counsel for the appellant has submitted that he is only aggrieved by the direction of the learned single judge whereby it has foreclosed the right of the petitioner to raise the ground that the presenting officer and the inquiry officer was the same in the disciplinary proceedings against the appellant. Full stop. We have heard the learned counsel for the appellant and has also perused the record of the departmental proceedings. Original record of the departmental proceedings produced by the counsel for the state of Assam. Full stop. From the record, it is clear that no inquiry officer, no presenting officer was appointed at any point of time during the pendency of the departmental proceedings against the appellant. Full stop. In such circumstances, when the presenting officer was not even been appointed by the appointed in the departmental proceedings, there is no question of the same person acted as presenting officer and the inquiry officer. Hence, we don't find any case for reference. This court appeal is dismissed.
Records be returned.
The original record will return to the counsel for the state of Assam. Original record of the department proceedings will return to the counsel for the state of Assam. Yes.
Item 33.
Please, your lordship. My lord, the appeal is directed against an order of the learned single judge,
33 and 34
which is at page 139. And while admitting the appeal, my lord, your lordships have observed that the matter requires consideration since there are divergent views of two coordinate benches in the case.
But the term is already over.
No, term is not over.
23, 24,
My lord, it is till June 2024.
it's going to be expired.
But even if I get something, my lord, I have invested money after all in the bid.
My lord, may I submit, my lord? This matters become infructuous, my lord. As because, my lord, lordship may kindly come to page number 42. This is the prayer of the writ petition, my lord.
Prayer of the writ petition.
Yes, my lord. Page 42 of the writ appeal number 21.
Yeah.
May I read, my lord? Issue a writ in the nature of certiorari setting aside the quashing the impugn settlement order number NZP so and so dated 36/2023 issued by the Chief Executive Officer, Nagaon Zilla Parishad, whereby the Balichatra bi-weekly market has been settled with the private respondent. Now, lordship may kindly come to the settlement order at page 56. Page 56 is the settlement order, my lord, under challenge in the writ petition, my lord.
Yes.
Yes. This is the settlement order and the last paragraph may be read, my lord. However, these settlements will be depend on the final order of the Honorable Guwahati High Courts in case number WPC number 3325/2023. Lordship may kindly come to now page 64. This is the order, my lord. An operative parties, my lord, page 73.
Yes.
Paragraph 19 is the interim order in that earlier case, my lord. This interim order shall not be understood as if the court has restrained the respondent authorities from proceeding with the settlement of the bids tender. Only retrainment is to exercise power under clause 10 of the bid. So after passing this order, my lord, that impugn order was passed. Settling the private respondent.
Respondent number 7.
Yes, my lord. Thereafter, my lord, what happened? In subsequent, my lord, event, that writ petition was withdrawn. Yes, where stay was there. And after withdrawal, my lord, the petition appellant here in my lord challenged that clause 10 in a separate writ petition. That was also dismissed.
Challenge what?
Clause 10, my lord. Now they are only on merit in clause 10, which was not a part of the prayer of that earlier writ petitions, my lord. They are now already, yes, yes.
That clause, no?
Yes,
3 days
yes.
Time to
Yes,
rectify
yes,
this.
yes, yes.
Clause 10.
Yes, there was a clause, my lord, clause 10, which empowers the authority, my lord,
To give 3
to
days
give
time
3 days time to,
cure the deficiency.
yes, yes, deficient document, my lord,
And
to
that
generate
has-
higher revenue, my lord.
Some of the case, I think so that has been stayed.
That was withdrawn, my lord. That case was
In
withdrawn.
some of the case, my lord, that clause was struck down saying that it violates Article 14.
Yes.
And that following that judgment, that precedent, my lord, the Honorable Single Judge in the 3325 case said that the clause 10 shall remain suspended and the proceedings, I mean, the settlement of market will be done without taking into account the existence of clause 10.
Okay.
So that is how the process was done and I was selected. Now, after my selection was done, then the writ petitioner, who is a private respondent here, he filed a writ petition saying that his tender was illegally rejected and therefore he wanted that my settlement should be struck down.
Then the court
Then,
is,
now the court has done this, my lord, without taking into account the fact that clause 10 itself was struck down by the Honorable Court in a previous round of litigation. And therefore, my lord, the question arises, since there are two different views of the Honorable Court from two learned single judges, one view is that the clause 10 is a valid piece of requirement. The other view is that it is violative of Article 14. That is why on the date of admission, my lord, if I can recapitulate the things, your lordships had held that this requires a consideration as to which of the view should be preferred. The interim order which was passed, pursuant to which the settlement was done in my favor, the interim order took the view that since there is already a precedent on the point, therefore that should be followed. If your lordship will kindly come to the observation of the learned single judge in the 3325 order, that is at page 64. And page 68, your lordship may straightway come, paragraph 11. May I read it to your lordship? Considering the rival submissions made in the matter, it is observed that in the proceedings of 690 to 21, the validity of clause 10 of the NIT was not under challenge because as per the facts of the said case, the bid of the petitioner therein was not compliant and therefore the petitioner therein sought to evoke clause 10 of the NIT so as to impress upon the court that he should be given an opportunity to furnish additional document to make his bid valid. Under the said circumstances, this court by an elaborate discussion had held that clause 10 was discriminatory and therefore the interpretation sought to be given on clause 10 of the NIT by the petitioner in WPC so-and-so was not accepted by this court, refusing to give liberty to the petitioner under clause 10 of the NIT to produce document. Accordingly, the writ petition was found lacking in merit and the same was dismissed. Therefore, the court is unable to accept the contention of the learned additional advocate general for the state that unless the validity of clause 10 is under challenge, observation by this court on clause 10 of the NIT in WPC number so-and-so should be considered only as obiter. Thereafter, your lordship has his lordship has discussed the meaning and purport of obiter, and your lordship can skip over page 69 to page 70, paragraph 13. From the above, this court finds support on the point that the observation of the coordinate bench of this court in 690 to 21 cannot be said to be an expression or opinion which was not necessary to support the decision used by the court. The reason is simple because in the proceedings of WPC number so-and-so, the petitioner therein had invoked clause 10 of the NIT to urge that he should have got an opportunity to supplement his tender, which is the proposition not accepted by this court. This court could not have taken an appropriate decision without applying its judicial mind on the scope and ambit of clause 10 of the NIT. Therefore, since only the prayer of interim relief is being considered, no point would be served to have an elaborate discussion on the scope and meaning of the word obiter as well as dicta, it appears that though the decision dated so and so passed by this court in coordinate in WPC number so and so was not placed before the coordinate bench of this court when WPC 437722 was decided, but it is submitted at the bar that reliance placed on the judgment and order dated 17/5/2002 passed by this court in so and so, which dealt with a similar proposition as was decided in so and so. It is observed that the coordinated bench of this court had expressed no opinion on the previous decision of the coordinated bench of this court passed in so and so. It is further seen that in paragraph 20 of the judgment in WPC number so and so, the coordinate bench of this court had referred to the order passed in so and so by referring to order passed in writ appeal number 204/2022, which was an appeal against the judgment passed in WPC 27. Nonetheless, from the website of the court, it appears that the said writ appeal was dismissed by order dated so and so on having been rendered infructuous. Therefore, it prima facie appears is that the decision of the court in WPC number so and so, which is stated at the bar to be similar to the decision rendered in 6902, had attained finality. Therefore, court is disinclined to follow the subsequent judgment of the coordinated bench in so and so, and in this regard, subsequent judgment having taken a contrary view would not have a binding precedent. This prima facie opinion is rendered only for the purpose of examining the prayer for interim relief and is not a final expression of opinion on merit, which is left open to be decided in an appropriate time. On examining the pros and cons of permitting a tenderer to supplement documents which are not accompanying the tender, the court finds that there could be a hypothetical situation where for specific intention a bidder bids may not elect to disclose all the document which he has. In a tender process, the tender bids are opened in the presence of bidders. Therefore, when a document is submitted with the bid, it will be open to other bidders to question the correctness of the validity of the documents produced. However, if by applying 10, a document which has never been brought on record along with the original tender is accepted by the tendering authority, other bidders would lose an opportunity to raise an objection against the document. Such an acceptance of a document which did not form a part of the bidding process would be an ex parte acceptance in the
23rd of November 2022.
23rd of November.
In the subsequent writ petition.
That is not part of this brief, my lord, but I have a copy. I can place it to your lordship. Four three seven seven. 437. Six and 02. Well, may I read the rest of this particular page 71?
Okay, fine. The single judge has this. Opined about the rule 10 and why he has not followed the lateral judgment.
Yes.
This is what the learned single judge.
Yes. So therefore, this 4377.
And this 23/11/2022 says that this clause 10 is valid.
Yes, it's okay.
Yeah, where is that?
Now, 23/11/2022, your lordship can come to the paragraph 8. Paragraph 8 at page 12.
Yes.
The learned counsel for the petitioners have immediately drawn the attention of the offending clause in the NIT, which is clause 10 in 4 of the cases and clause 11 in 1 of the cases, and it is not in dispute that the expression wordings in both the clauses are exactly the same. By the aforesaid clause, it has been stipulated that the bid of the highest bidder would be accepted for consideration and the said bidder would be given 3 days' time for submission of necessary documents except court fee and earnest money deposit. And if the said bidder fails to do so, the second highest bidder would be offered the settlement with the same conditions. Assailing the aforesaid clause, the submission of the learned counsel for the petitioners are that The said clause is in gross violation of the right to equality, as a favorable treatment has been sought to be given to a bidder whose bid itself is an invalid one. It is submitted that the importance of the quantum contained in the bid would be of relevance only when the bid is adjudged to be a valid bid, and unless and until necessary documents and criteria are submitted or met by a bidder, the bid cannot be considered as a valid bid and is liable to be rejected. It is further submitted that the said clause itself is in violation of another clause of the same NIT, namely clause 17. Here also, my lord, the clause 17 is there, which is also adumbrated as 18 in few of the tenders. Clause 17 states that if any of the conditions mentioned in the preceding clauses are not fulfilled, the tender application is to be rejected. It is contended that in view of such clear stipulation in the NIT, the scope of consideration under the offensive clause will not arise at all, and therefore the aforesaid clause is liable to be declared unreasonable and accordingly set aside. Then paragraph 9, the learned counsel for the petitioners have strenuously argued that highest bid actually means the highest valid bid, and in this regard, a decision of this court in the case of so-and-so versus so-and-so reported in so-and-so has been pressed into service. The relevant paragraphs are extracted. Your lordship can skip over that, my lord. And finally, my lord, after discussing the some case laws on the point, my lord, your lordship can skip over to paragraph 20 at page 17. Sri F.K.R. Ahmed, learned counsel for the petitioners, places reliance upon an order dated so-and-so passed by this court in WBC so-and-so, Rafiqul Islam, in which this court has dealt with a similar subject matter, and against this judgment dated so-and-so, a writ appeal being this reference your lordship has got in the previous order. Sri Ahmed has submitted that the present arrangement has been done in accordance with government notification at an escalated rate of 25% above the earlier offered rate. The rival submissions made by the parties have been duly considered, and the materials placed before this court have been duly carefully examined. Before going into the issue involved, this court is of the opinion that the examination of the same would be restricted for only those petitioners who have locus to maintain the present challenge. In other words, the present exercise cannot be turned to be a mere mechanical one, where an issue has been raised by a party who would not be in any way affected by the result of the same. In the instant case, it appears that few of the petitioners did not even submit the bid, and so far as one of the petitioners is concerned, his bid is 13th in rank so far as financial aspect is concerned. For those petitioners, this court is not inclined to examine the issue on the merits, even if a case is made out, as the result of the same is not going to have any effect whatsoever on the said petitioner. Having said that, the issue is required to be adjudicated so far as the petitioners who have submitted their bids in response to the said NIT are concerned. The challenge is regarding a clause which gives 3 days time to a highest bidder to submit furnished documents in support of the bid as required in the NIT. A minute examination of the said clause would show that such liberty is given for documents other than earnest money deposit and court fee. A bid without being accompanied by court fee and earnest money in any manner cannot be taken into consideration. However, in case of other documents which are also necessary to construe the bid to be valid bid, 3 days time is given to the bidder whose financial bid is otherwise found to be the highest. This court finds force in the contention of the learned standing counsel of the department that the objective is only to ensure that maximum revenue is fetched in the tender for allotment of markets, ghats, minimal, etc. This court has further noticed that the period granted is limited to 3 days, enabling a highest bidder to furnish the documents which might, in a given case, not be available for or could not be charged at the time of submission of the bid on the last date. The clause further stipulates that the liberty is not an unlimited one, but only for 3 days, whereafter the turn of the second highest bidder would come and with the same conditions. Such a clause in the considered opinion of this court cannot be termed or construed as unreasonable or arbitrary, and rather the same appears to be in consonance with the principles of fairness and transparency, as a fair opportunity is given to ensure the maximum review earned by the state. Now, while observing this, my lord, the previous decision of the point, which the learned single judge in the present case had discussed, that was not neither taken into account nor any opinion.
A reference was there.
Yes, there was a reference, but no opinion was there. So the honorable single judge in the present case said that since that is a decision earlier in point of time, that should be regarded as a binding precedent and not the later one. And therefore, this particular judgment in 4377, that was not preferred. And while coming to this proposition that the previous judgment should be given more valid reason, my lord. The learned single judge has say, refer to a decision of the Honorable Supreme Court in Pranay Sethi's case, where, my lord, this position has been very succinctly laid down. Your lordship will find a reference of that in page 72 itself. I was just reading about 10th line from top. Huh? The situation, it starts with, the situation in the opinion of the court is hit by Article 14 of the Constitution of India, as an equal opportunity has not been granted to all the bidders to examine the validity of documents submitted subsequently by a highest bidder. It is too well settled that bidding process must be done in a transparent manner, and everybody who is present in opening of bid should be made aware of the nature of documents which are accompanying the bid. If such an opportunity is lost, it cannot be said that the principles enshrined in Article 14 of the Constitution of India is not violated. Therefore, the court is inclined to follow the earlier judgment of this court dated 17/5/2022, passed in 6902, as having more persuasive value than the subsequent judgment dated 23/11/22, passed by a coordinate bench in so and so. As in the subsequent judgment, the previous order of this court was not considered and distinguished by applying judicial mind. In taking the aforesaid view, the court finds support from the Constitution Bench decision of the Supreme Court of India rendered in the case of National Insurance Company Limited versus so and so, where the Supreme Court of India had observed that disagreement with earlier judgment of coordinate bench was impermissible. Hence, being bound by the ratio laid down by the Constitution Bench of Supreme Court of India, the court would be inclined to accept the decision dated 17/5/2022, passed in WPC 6902. Now, if I may place the judgment of the Honorable Supreme Court, my lord, which the Pranay Sethi's case, lordship will kindly. Yes.
Yes.
Now, your lordship may kindly come to paragraph. Paragraph 16, my lord. It starts from 14 at page 696. The aforesaid analysis in so and so may prima facie show.
16.
Sorry, my lord, 14.
Yeah.
14. The aforesaid analysis in so and so may prima facie show that the two-judge bench has distinguished the observation made in so and so, but on a studied scrutiny, it becomes clear that it has really expressed a different view than what has been laid down in Sarla Verma. If we permit ourselves to say so, the different view has been expressed in a distinctive note. For the two-judge bench has stated that it was extremely difficult to fathom any rationale for the observation made in para 24 of the judgment in so and so in respect of self-employed or person on fixed salary without provisions for financial annual increment, etc. This is a clear disagreement with the earlier view, and we have no hesitation in saying that it is absolutely impermissible keeping in view the concept of binding precedent. Presently, we may refer to certain decisions which deal with the concept of binding precedent. Paragraph 16, in state of Bihar versus so and so, it has been held that an earlier decision may seem to be incorrect to a bench of a coordinate jurisdiction considering the question later on the ground that a possible aspect of the matter was not considered or not raised before the court, or more aspects should have been gone into by the court deciding the matter earlier. But it would not be a reason to say that the decision was rendered par incuriam and liable to be ignored. The earlier judgment may seem to be not correct, yet it will have the binding effect on the later bench of coordinate jurisdiction. The court has further ruled, easy course of saying that earlier decision was rendered par incuriam is not permissible, and the matter will have to be resolved only in two ways, either to follow the earlier decision or refer the matter to a larger bench to examine the issue. In case it is felt that the earlier decision is not correct on merits, in so and so versus so and so, the court has accepted the said principle on the basis of judgments of this court rendered in cases so and so, it may be noted there here that the coordinate constitution bench in Madras Bar Association versus so and so has clearly stated that the prior constitution bench judgment in Union of India versus Madras Bar Association is a burning precedent. Be it clarified, the issues that were put to rest in the earlier constitution bench judgment were treated as precedents by the later constitution bench. In this regard, we may refer to a passage from so and so versus so and so. Law will be bereft of its utility if it should be thrown into a state of uncertainty by reason of conflicting decisions, and it is therefore desirable that in case of difference of opinion, the question should be authoritatively settled. It sometimes happens that an earlier decision given by a bench is not brought to the notice of a bench hearing the same question, and a contrary decision is given without reference to the earlier decision. The question has also been discussed as to the correct procedure to be followed when two such conflicting decisions are placed before a later bench. The practice in the Patna High Court appears to be that in those cases, the earlier decision is followed and not the later. In England, the practice is, as noted in the judgment in Gundaburuppo Theshamma versus so and so, that the decision of a court of appeal is considered as a general rule to be binding on it. There are exceptions to it, and one of them is thus stated in Halsbury law. The court is not bound to follow a decision of its own if given par in curiam. A decision is given par in curiam where the court has acted in ignorance of a previous decision of its own, or of a court of a coordinate jurisdiction which covered the case before it, or when it has acted in ignorance of a decision of the House of Lords. In the former case, it must decide which decision to follow, and in the later, it is bound by the decision of the House of Lords. In so and so versus so and so, it has been held by the Andhra High Court that under the circumstances aforesaid, the bench is free to adopt that view, which is in accordance with justice and legal principles, after taking into consideration the views expressed in the two conflicting benches. Wide also the decision of the Nagpur High Court in so and so versus so and so. The better course would be for the bench hearing the case to refer the matter to a full bench in view of the conflicting authorities without taking upon itself to decide whether it should follow the one bench decision or the other. We have no doubt that when such situations arise, the bench hearing cases would refer the matter for the decision of a full court. Though the aforesaid was articulated in the context of the High Court, yet this court has been following the same as is revealed from the aforestated pronouncement, including that of the Constitution Bench, and therefore we entirely agree with the said view because it is precise warrant of respecting a precedent which is the fundamental norm of judicial discipline. In the context, we may fruitfully note that what has been stated in Pradeep Chandra versus so and so and so and so. In the said case, the Constitution Bench was dealing with a situation where the two-judge bench disagreeing with the three-judge bench decision directed the matter to be placed before a larger bench of 5 judges of this court. In that scenario, the Constitution Bench stated, in our view, judicial discipline and propriety demands that a bench of 2 learned judges should follow a decision of a bench of 3 learned judges. But if a bench of 2 learned judges concludes that an earlier judgment of 3 learned judges is so very incorrect that in no circumstances can it be followed, the proper course for it to adopt is to refer the matter before it to a bench of 3 learned judges, setting out, as has been done here, the reasons why it could not agree with the earlier judgment. In Chandra Prakash versus so and so, another Constitution bench dealing with the concept of precedents stated that the doctrine of binding precedent is of utmost importance in the administration of our judicial system. It promotes certainty and consistency in the judicial decisions. Judicial consistency promotes confidence in the system, and therefore, there is the need for consistency in the enunciation of legal principles in the decisions of this court. It is in the above context that this court in Raghuveer Singh held that a pronouncement by law
Now, in this case, what happened?
Now, here, my lord, the first judgment that the Honorable Single Judge referred to was that this clause 10 is arbitrary.
Yeah.
And therefore it cannot be acted upon.
Okay.
The later decision.
They said it's okay without any. Yeah.
Now in the facts, what has happened in the facts of the case? I'll just place a chart of events.
Here in this case.
Yes.
Yeah.
Now, how things have moved in this particular case, my lord, I'll just place a chart of events before your lordship.
But Mr. Datta, just to point out one thing, in this later judgment, the learned single judge is taken note of clause 17.
Yes, clause
Uh,
17 is also here.
Is there in this,
Yes, yes.
the first judgment?
Yes,
also?
yes. This is, my lord, the clauses are identical. What's
The numbering is different.
sometimes, my lord, numbering, my lord, 10 becomes 11 or 17 becomes 18, but the clauses are same everywhere. Now, here, my lord, on 29th of April 2023, the NIT was issued.
29th of April,
2023, the NIT was issued, and it contained this particular clause, namely the clause 10. Thereafter, my lord, on 9th of June, my lord, this order was passed.
Which order?
The order that 33 in 3325, page 64.
Earlier judgment.
Yes, no, the stay order.
In earlier proceeding, earlier it was.
Stay order passed by the Honorable Single Judge in a proceeding, my lord. That is at page 64. Now, page 64, your lordship will just see the particular order, my lord, that I was reading out to your lordships in WPC 3325 of 2023.
Yeah.
Now, this stay order was passed saying that since there is a binding precedent on a previous occasion, so clause 10 should be stayed. And the final observation at page 73 that your lordship will kindly see.
The interim order shall be understood by the court restrain the respondent authorities
From proceeding with
the
this-
settlement bids, only restrain the excess section clause
10.
10.
10. So therefore, my lord, after this order was passed, the respondent Anchalik Panchayat issued a notice on 19th of June. 19th of June, that is at page 135. 19th of June, the Anchalik Panchayat notified that in view of the order passed by the Honorable Court, clause 10 will not be taken resort to and bids will be processed on its own merit. Thereafter, on 30th June, my bid was accepted.
Okay.
The bid by the private respondent was rejected on the ground that
The documents were not there.
documents were not there. And he was also not on the, another fact is that he was also not the valid highest bidder.
Okay.
So on these two counts, my lord, the bid was rejected. Then,
You were the highest bidder or second, third bidder?
no, I am the, in the numerical assessment, my lord, I am the fourth, but in the assessment of the valid highest bid, my lord, I am the valid highest bid. I am the first. Now thereafter, my lord, the private respondent filed a writ petition. Private respondent filed this writ petition from which, my lord, the appeal has arisen. Private respondent filed this writ petition primarily on two counts. First of all, his allegation was that just like as his bid, my bid also did not contain necessary documents. And therefore, my bid should not have been accepted. Because by accepting my bid, the authorities have in a way indirectly applied clause 10 in my case to the detriment of his bid. That was one of his contentions. The second contention is that in filing the bid declaration form, I made an incorrect declaration. There was a requirement to state that whether I previously held any settlement in my favor or not. I said no. They said that, I said yes. They said it should be no. So in a way, they want to say that only on these two counts, my lord, the
Petition was filed.
petition was filed. Now, in response, my lord, I stated one thing I must clarify: there was no affidavit from the side of the panchayat or from the side of the government. Now, in my affidavit,
Proceedings.
yes, in the writ proceeding. Now, in my affidavit, I said that whatever documents were required, that I had submitted, and in fact, my lord, there was an assessment of
Your case was that my bid was not defective.
not defective. And to that extent, my lord, I relied on the assessment made by the panchayat.
Fine.
Now, without going into this aspect of the matter, my lord, the Honorable Single Judge has said that entire matter should now go back to the authorities. Authorities should redo the exercise by applying clause 10 without any change into the bid value offered by us. Now, if that is to be accepted, my lord, that will amount that it will certainly ensure award of the, settlement in favor of the private respondent.
Resorting to clause 10.
Yes.
Again, they.
Yes. Now, therefore, the problem arises. And another, and another aspect of the matter is that, my lord, After the settlement was made made with me in my favor, my lord, I deposited the kist money, which is I am required to do to run the market, my lord. I deposited the money. They realized money from me.
And at present, who is running the?
At present, my lord, because of the order passed by the honorable single judge, it is the panchayat who is running the market. Neither I am gaining nor the private respondent is gaining. But my only contention is that, my lord, if the honorable single judge would have referred to the previous decision, which in the single bench has said that is the binding precedent, my lord, then it's a definite case in my favor. Because therefore, my lord, I would humbly submit that your lordship will be kind enough to actually examine the validity of the two views. Because that is the.
Let him come.
Just I'm submitting this.
So that is one of the aspect of the matter. The second aspect of the matter, my lord, what is one of the contentions of the appellant, even if, my lord, we assume for a moment that the honorable single judge was justified, my lord, I am making this as an alternative submission. Even if we assume that the honorable single judge was justified in redirecting the matter to the panchayat for a fresh exercise, the right course of action would have to be to ask for a fresh tender, because besides me and the private respondent, there are also other bidders. Since it is a matter concerning distribution of public largesse, my lord, it cannot be confined only to the writ petitioner and the appeal, the respondents. The other persons will also have to have a say in the matter.
Learned single judge has recorded any finding that your bid was defective?
Yes, Learned single judge has recorded this finding, my lord, which I have challenged in the present appeal. That is without any, just on the basis of the affidavit filed by the writ petitioner. The writ
Without
petition.
there any response by the panchayat and any other?
Yes, without any response, there being any response. And my contention, on the contrary to the contention raised by the petitioner, my lord, my contention was
How
that
much money you have deposited?
money.
How much money you have deposited?
Something around 1.52 crores, maybe. Sorry, 1.18 was my bid. Almost 70%. 70%. Well, my information is that about 80% of the total value, that will be around 1 crore. Why it is 80% of 1 point. Settlement value was 1 crore 52 lakhs.
80% you have
Oh,
deposited.
yes,
That money is lying with them.
with the panchayat.
They are not returning it to you.
They have not returned. They have not returned.
If we make an order of returning that money, then
My lord, I am not. My lord, money is one of the considerations. Of course, my lord, it's a commercial contract. But since I have invested money, I am much interested in generating the.
invested money since you have deposited only,
Yes.
otherwise the what is
No,
the
my lord,
investment?
if I run the market, my lord, I deposited the money with the only intention of running the market so that I can generate revenue for my benefit.
Then
Now,
how much
return.
revenue will earn in 2 months or less than 2 months?
Still, my lord, one in hand is better than two in the bushes. My lord, I'll be getting at least some months to run it.
But Mr. Datta, those things apart, the legal issue has to be decided here.
Yes, exactly.
And that will require a little, we have to hear arguments.
Yes. So that's why, my lord, reply to my learned friend's submission will be that it is not as such an infractuous appeal that I am arguing.
No, it's not infractuous.
It's not an infractuous appeal that I am arguing.
Lordship, prayers of that repetitions are different. my lord.
It's all right. no, it's all right.
Nothing, since
One,
infectious for the purpose when there are two views and we have to decide which view is correct.
my lord.
It can't be infectious.
That part, my lord, clause 10, the petitioner have challenged in single, before single judge again, my lord.
Again,
But that was also dismissed, my lord.
No, that is on a different, I can answer all these things,
There-
my lord. That was,
fine,
maybe a
that
very
is
good-
dismissed that is again by the learned single judge.
Yes, another bench.
So here now the matter is before the division bench, we have to decide.
Yes, my lord. But my lord, the issue of the writ petition is not the challenging of clause 10, my lord. That is why I am submitting, my lord.
That is not of.
Clause 10, challenging clause 10,
No
ma'am.
clause 10, but his argument is there. Okay, the learned single judge has directed to resort to the clause 10, which has already been declared as ultra virus.
My lord, that part, my lord, of another writ petition, my lord, that was already withdrawn. That in interim of another proceeding, my lord. And that was set aside also, my lord, that interim order was. When withdrawn, my lord. In this particular writ petition, my lord,
Now, since the question before us.
yes, my lord.
The
like
clause
lordship
10
can.
entity regarding the clause 10, we'll consider it and decide.
What is your urgency? What
Urgency,
urgency?
my lord, because we are running by departmentally, my lord, only.
You don't want to run.
My lord, we
Give
want to
it to
settle
him.
and to give more higher revenue, my lord.
if he
You are
wants
not-
to
you
quote
are
a
the
fresh
private
tender, my lord,
respondent.
it's a different question.
You are the
I'm
private.
not, in fact, I am saying, my lord, private respondent is also
You are-
now
you are
not getting,
panchayat.
my lord,
You are
because,
panchayat.
yes, my lord,
You are panchayat.
I'm from the department, my lord.
No, he is from the department, Panchayat and Rural Development Department. The Panchayat is,
I'm not for the private respondent.
You are not from the private.
Yeah, in fact, my
it
lord,
is being run by the Anchalik Panchayat.
now clause 10 is after withdrawal of that order, my lord, interim order. Now clause 10 is valid. Therefore, my lord, we can go with the higher bidders, my lord, with the help of clause 10, my lord. To revenue, more revenue, my lord. Because in earlier those cases also, my lord,
Formulate a question. And put the part in the.
and one division bench order I have handed over, my lord. In that clause 10 order, my lord, was challenged by one of the petitioner. That was also rejected, my lord, saying that before participation, he was not challenged.
No, that's altogether different.
Division bench order, my lord.
Yeah, division bench order without going into the validity of the clause 10.
My
He
lord,
said
may
that
kindly,
since before applying, he has not challenged, therefore it is not open for him to challenge now.
yes.
This is what that's all.
In the present case also same, my lord. Before participating, he didn't challenge. He was only beneficiary of that interim order.
Why he should challenge that? Because the
My lord.
single judge has already declared that it is ultra virus.
No, my lord. In the first order, that was not declared ultra virus because that in that case also, clause 10 was not challenged and that was only a running comment, my lord.
Even though if
What is
it was
running?
not challenged and came into the notice of
In
the
the
court
second-
that this is such a provision and the court has gave a declaration that it is ultra virus, what's wrong in that? That can be done.
In the second case, my lord, the clause 10 was particularly challenged, my lord. And the order was passed, which was for preferred appeal against that order, that was dismissed, my lord. By division bench, my lord.
Let us see.
I've submitted that order also, my lord.
Mr. Mohanty also.
Yes, there is a academic discussion all right, but my lord, this is neither he is challenging, my lord, neither I challenge. I am the writ petitioner. I am challenging, my lord, his settlement order because there is a shortfall of document. That is, my lord, apparent because that is, he is also not denied, my lord.
No. There is a specific denial, my lord.
Let
I'm
me
sorry to
finish.
interrupt, my
No,
lord.
let him finish.
There is a specific denial. If well, that's why I said that these are the 2 points on which the writ petition was filed, that my documents were not complete. And my response to that particular statement is at paragraph, page 103. His statement, your lordship will find at page 30 in the writ petition. And my reply is there.
Finding of the learned single judge after perusing record, my lord, there is a shortfall of the document in respect of the, my lord. Both the parties, my lord, respondent as well as the writ petitioner, my lord.
And I made a specific amendment in my writ petition, my lord. There is no specific denial to that. my lord.
Writ petition WPC 3325 is still pending.
No,
No.
that is the, my lord, that is, I am.
3325 has been withdrawn
My
by
lord,
the
just a minute,
person
my
who
lord.
had
Let
filed
me
it.
finish,
Uh-huh.
let me finish because, my lord, I just pointed out. Now, my lord, yes, I agree that there is academic discussion, I agree, my lord. But my lord, his settlement order is a conditional order. So that condition, without, my lord, suppose there is no retribution, anything is filed. But his life is up to that is, my lord, your lordship, kindly see the last line of this, my lord, his settlement order, kindly see, my lord.
Now, even if we stay this order passed by the learned single judge, then you'll not be able to get the contract because as per them, your bid is defective.
No, that required a determination, my lord.
That is the finding of the learned single judge.
That required a determination.
Determination.
Yes.
कर लेंगे.
And therefore, my lord, I can still try to convince your lordship that my bid was not defective. At least, my lord, the learned single judge has recorded. Learned single judge has recorded that there was a minutes of proceeding which was produced before the court.
Yes.
And in the minutes of the proceeding, my lord, the authorities have recorded me as the highest valid bidder. And that particular part of the matter was not even challenged in the writ petition. There is a
No, Mr. Datta, there are two aspects. What my lord, the Honorable Chief Justice is asking is that during pendency of the appeal, if the order of the learned single judge is stayed, that does not automatically lead to you taking over unless there is a positive direction to that effect, which in an interim may not be possible. Second thing is, if the order of the single judge is not set aside and a mandamus this way, that way is not issued, the department will continue to run it themselves.
Yes.
And that will not be possible unless the court gives an opinion on which of the two views on clause 10 is correct. The matter will require some hearing,
Yes.
which will not be possible today.
No, not today,
So
my
the
lord,
only thing we can talk about is which date.
Yes, that
Which
is
is the
that
date,
is it.
next day.
Any time, my lord, immediately after the vacation, my lord, due vacation.
My lord, may I point out one thing, my lord? Your lordship, kindly see page 56, my lord. Kindly page 56, my lord.
56.
56.
Yes.
That is the settlement order of my lord, private respondent, Elite Appellant, my lord. That was
In his favor.
in his favor. That was a conditional order. Your lordship, kindly see. The last line, my lord. Page 56.
However, the settlement shall depend on the final order passed by the Guwahati court and.
Already, my lord, final order passed in that case. So that is not been challenged. So, my lord, if he is assuming that there is no case, my lord, no case, my lord, even then he will, my lord, lose. Until unless he is not challenging that order, my lord. In that way, my lord.
I think this
Subject to 3325 that has been dismissed as infectious, no merits. Not decided on merits.
Not decided on it.
Then-
Withdrawn, my lord.
That was
That is
withdrawn.
withdrawn. Withdrawn by the parties. So, my lord.
Therefore, my lord.
Therefore, my lord, he's automatically, there is no case at all. Even
Why,
then, my lord,
why don't we hear it in the month of September?
my lord, nobody will be
My
benefited.
lord, only thing is that, my lord, if even if your lordship hears it in the month of September, there should be the Anchalik Panchayat, who is not represented, I guess. They should be allowed to float. Oh, they should be allowed to float the tender in the month of June, where we can all participate.
But what about this clause 10?
No, that, my lord is saying that lordship will be deciding it in the month of September.
They are only concerned.
Put upon
will run,
24th, put upon 24th, or on that day, produce the minutes of the meeting.
Or can it be preponed by one date, my lord, 23rd
25th.
or 25th
23rd.
or 25th, my lord?
Twenty-fifth.
Deeply obliged. My lord, the status quo order may be continued, my lord.
Interim order limited hai.
That was still today.
Interim order to continue till next date.
Obliged.
Interim order passed that day to continue till next.
Biplab.